take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause SweetP's on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when SweetP's in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Rachel with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. SweetP's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know SweetP breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you write a line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. SweetP's got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. SweetP says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. SweetP's nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Estoy en la casa, baila conmigo, San Diego to the chat, órale, vámonos. From the surf in San Diego to the courtroom stream, SD walks in like she owns the scene, pelo multicolor shining in the sun. She cracks one joke, chat laughing as one. She throws preguntas bien chidas, sharp like a blade, cross exam queen, nunca tiene upgrade, and that dance so spicy. Cali mistakes close, she brings the fuego, everybody knows. Cuando Jason llega, ay caray, she flirts poquito, he just says hi, SweetP laughs. Aquí vamos otra vez, SD drops the fuego and the chat says yes. She's fuego, fuego, lighting up the show, Tex-Mex in the chat, everybody knows. Con su risa, su vibra y su pelo tan cool, she turns the live stream to a cumbia atapour. Fuego, fuego, SD's the queen, Spanglish magic en la chat screen. When she pops on camera, we all say que show. Latina sparkle with that California glow. Los mos la quieren, they hype her name. She adds flair y sabor to the game. ¿Qué onda, gente? And here comes the fun. El chat se enciende like under the sun. When she teases Jason, boy, behave. But without a chaos, this chat ain't the same. Bailalo, mija, with your Tex-Mex vibe. Bring the cumbia flow, keep it alive. Stay with the groove, don't ever stop. Shake up the stream till we're all on top. She's fuego, fuego, let her up the show. Tex-Mex in the chat, everybody knows. Con su risa, su vibra y su pelo tan cool, she turns the live stream to a Latin dance floor boom. Fuego, fuego, SD's the queen, Spanglish magic en la chat screen. Beach girl sparkle, courtroom delight, SD keeps the chat shining bright. SweetP, the mods, we all agree. Take it to trial, ain't the same without SD.
Okay. We'll play the rest of our songs on the end. I know and it sounded better. It must have sounded better because SD done threw her phone down now. There she goes. She back. Look, she said yes and tried to translate. Welcome, Christine. Welcome. Glad to have you here. Oh, thank you, Allison. Oh, thank you. It was okay. I downloaded them onto my little sound thing, so we should be good. Christine, I put the link in there for the membership if you want to join. I think it's $3.99, I think. Yeah, we would love to see you and Greg. Oh, look at Barbara. Barbara say, here, I dropped 5 on it. I got 5 on it. She's like, come on, 5 of you. Y'all make sure y'all stick a shout out to Allison and Barbara for their gifted memberships. Thank you so much. You did? Did it hit her? Allison, did you get it? Did you get her? Let me see if your shot good. Let me see. Yeah, yours went to Deanna. Awesome. So Deanna, I gotta look in another screen to see who got them. Y'all can see them right away. You say, please give it to Christian. It won't allow me to give them out to people. I can't. It's random. Yeah, I wish I could. I can't. If I could, I would give them to the regulars over here, right? But it randomly sends it out. But whoever, we got newbies. We got newbies. Marilla said she's been trying to hit Dandy for the longest. Yes, I definitely appreciate it. Thank you so much, Barbara and Allison. And yes, Christian, I did put am I calling? I'm probably saying, y'all know I'll be saying stuff. Christine. It's Christine. Y'all just be letting me do stuff. Christine. Oh, Barbara really trying. Barbara said she gonna get somebody. Y'all say thank you, Barbara. Thank you, Barbara. Oh, wait. Welcome all the newbies. Yes, and please don't forget to hit that like button as you coming in and taking the seat. All our new members. Thank you. Thank you so much, Barbara. Thank you so much, Allison. Thank you to both of you guys. Truly appreciate it. You know, this doesn't work without you guys and this great chat that we have going on here. Shoot. Oh boy. So we supposed to go into this. We're going over here to look at these closing arguments for our pageant redrum trial, right? I think they just got finished doing their closings. Yeah, I'll probably have to watch that later. I'm thinking of Jarvis Butthead is back in court today, y'all. I'm so sick of him. He another one I'm sick of. He another criminal essayer that I am so sick of, but he is in court today, and I'm gonna have to look at it because I plan on us covering that trial, so I may do a little something on him a little later for us so we can make sure we can stay up to date. I didn't know if they were going to stream it or not, but it appears that they are. So we'll catch up with Mr. Butts a little later. But he currently in court now. He on my nerves. He make my ass hurt. Like literally, he make my ass hurt. Sorry. Give Christine F4J a bit of download on this trial. Are you speaking in Oh, okay. So a little background on this case, Morel, does what you would like me to give? I mean, it's like speaking in tongues to me right now. Jason, thank you so much, Jason. Oh, he said, thank you, seductive SD. Shoot, amazing. Wait a minute. Now, wait a minute. Yeah, I believe so, SD. I don't even know who that guy. I don't. Yeah, I see his stuff is on there. Luigi. I keep thinking of Mario Brothers. Barbara said we all love Jason. Wait a minute, Wody. You know, sharing is caring. Well, he got up in here to talk about some damn seductive SD. I'm feeling what's it? Wait a minute. No, just kidding. Don't let me nobody. I told you I don't like to be the side chick. So long as I ain't the side chick, we good. He unalived the CEO of United Healthcare. They showing this trial. SD. Wait a minute. Marilda asked me to do something. She said, no, I am not speaking in tongue. That is Christine Handel. Okay. Because I was like, what is F4J a bit? I'm reading it all out. Okay. So just to kind of recap where we're at, we are going into closing arguments, but no worry. This case is in regards to a young lady who was very spiteful, hateful, could not stand her boyfriend, I guess on and off again boyfriend's son. And she did some very bad things to him. I don't know I don't know exactly how she attacked him, but she's saying that he fell out of the chair, but it appears that she redrummed him. Anything in regards to this, I do have no fluff versions on the channel. So day 1, 2, and 3. This case is in Georgia. So basically her defense at this point in time is she's trying to say he fell out the chair and that's how he sustained. He's only 18 months old. And that's how JD sustained the injuries that he had. During the time that she had him, the dad was at Walmart. He wasn't gone that long. He went to Walmart to get a piece. He went to go to Walmart to get Pampers, and he brought back pizza. By the time he came back, his son was unresponsive. They went to the hospital, and they found all these injuries, talking about lacerations all the way down to his liver. So we have 3 days worth of trial. The defense put on 3 witnesses that basically just said that she babysitted their kids. And then they put on some witnesses that the prosecution had put on. So they like reuse witnesses, which was kind of weird. It like they didn't have a case. So basically all her witnesses kind of like backfired on. I don't know what they did. They was pointless. Let's say that. So now today we are closing arguments, which will give us a little bit more detail on what the prosecution thinks and also what the defense thinks. I hope that was a quick rundown. Maybe it was. But that's okay. They're going to tell us all in the closing arguments, guys. Okay, so let's go into our trial. Because I think the jury is deliberating. And we want to kind of get this before we get a verdict, guys. Okay.
One juror. Yeah, we're waiting on one juror. Let me know when you're ready. All right. All right. What is it, you just waiting on it to crank up? Okay. Going. Sherry, can we check and see what the status is on the jurors? I know they're supposed to stick their head in and tell me. We were waiting on one juror according to bailiff when I walked in. I also put I think Mallory gave you the verdict form for each of you to use during your closings if you wish to.
How she feel now? He over there with his new boo, because this got to be his new boo, y'all. This got to be the new boo. Yeah, that's the new boo right there. Wow. Nah, I don't think it's a friend. Nope. That's the new boo. And that's okay, because she probably really sitting over there with the eat face. No, he said the baby. Well, I don't know. It could be the baby mama, but he said the baby mama. I think she Mexican. SD, what you mean they deleted 200 videos I posted? Who? He trying to get a good look, Jason. I think they're trying to get a look at her. Yeah, he trying to get a look. I don't know if the baby mama there. Oh, she talking to, okay. No, SD said she having over 200 videos on her channel. You talking about your channel, SD? I don't know. Oh, she said now she only have 4. Oh, really, SD? I never knew you had a channel. But okay, I'm gonna stay out y'all business. Oh no. Oh no, Christine. What happened? I don't know what happened. I think I see. Uh-oh. Jason said he heard about that. All right, I'm gonna play the video and catch y'all in chat.
Otherwise, is everybody ready to proceed? All right. As soon as the jurors are here. Okay. When we have all 12 jurors, I'll come back in and we'll go right into the close arguments. If anybody needs a break now, big time. Good morning. Is everybody ready to proceed? All right. We're about to allow the attorneys to present their closing arguments. The state has the burden of proof in the case. First of all, did everybody have a good evening? Did you all follow my instructions yesterday? All right, thank you. We're about to proceed with closing arguments. The state, having the burden of proof, has the right to open and conclude the arguments. During the morning, as these arguments proceed, we'll take breaks, even if we're in the middle of one of the attorneys' argument. I don't like to do that, but I will most importantly want you to be comfortable and alert. All right. Mr. Lamb, does the state wish to make an opening argument?
I do, Your Honor.
All right, you may proceed.
One moment. Move this over. Can I get up there yet?
Please, everybody, make sure that your phones are off.
Tuesday morning, I stood here and I told you that what this case was about was the short life and the horrible death of one precious little boy. By now, of course, you know who that is. It's J.D. Angeles, born June 25th, 2022. He died January 14th, 2024. The state, of course, has charged Trinity Poague with causing his death. She's charged in an indictment which contends that she committed several violations of the law, several huge crimes, beginning with cruelty to children, aggravated battery. From each of those felonies, there's a charge of felony murder. And then finally, there's a charge of malice murder. And when you get to the point where you're having to move from this, we have this fact and we have this allegation. How do you get there? And there's really not, the judge is going to tell you what the law is, okay, but there's not really in the judge's instructions. Typically, there's not really a roadmap for how you get there. And so what I would suggest to you, ladies and gentlemen, is this. And again, I mean, you are free to decide the case however you choose to decide the case and by whatever process you choose. But I would suggest to you or submit to you that you might consider this process. And that is, you start with the facts that are beyond dispute. The things that you know that are established, where there's just not a realistic argument, where there's not a realistic dispute, where there's no controversy. Start there. And then the reason you start there is this, because you can resolve the disputed issues in the way that is most consistent with the facts that aren't in dispute. Okay, so if you know that 2 and 3, that these two things are true, and then you're trying to decide whether this third thing is true or not, you can take that third thing and view it through the lens of what you know, of what you've already established or what you've already decided is an indisputed or undisputed issue. Once you determine what happened factually, then you can apply the law to the facts. And of course, Judge Sizemore is going to give you a long explanation of what the law is, and he's going to tell you something very much like this. It's something that says to the effect of, you are the judges of the facts of the law, that you determine the facts, and then you apply the law to the facts to determine the outcome of this case. So for this part of my argument, what I want to do is this, ladies and gentlemen, is focus on some facts that are absolutely, at this point, indisputable in this trial. There is an indisputable medical fact in this trial, and that is that the cause of this child's death was massive head trauma. There's no question about, did he die because he had an infection? Did he die because he lost his leg and bled to death? Did he die for any one of these other reasons that might cause someone to pass away? In this case, the unanimous opinion of the medical witnesses that you heard from, the physicians that you heard from. I'm not talking about Dr. Gamble now. I'm talking about the actual doctors, okay, who testified in trial. Okay, Michael Busman, who's practiced medicine in this town for 30-something years. Jill Olek, who has practiced medicine in this town for 15 or 17 years. Dr. Anthony Clark, who has served as a medical examiner both in Georgia and Florida, for the last 30-something years, who's done 8,100 autopsies, who's testified in court as an expert witness hundreds of times as to the cause and manner of death. They all agree this child died from this wound. There are other injuries, and we're going to talk about those later in my argument, okay? But for right now, I want you to focus on this one, and that is that it is an undisputed fact that this child died from head trauma. It's also undisputed that the trauma or the cause of the trauma is also undisputed. Dr. Clark says it was a tremendous impact to the back of the head. These are quotes I wrote down while I was listening to the testimony. He says it was a tremendous impact to the back of the head. Dr. Busman says it was a direct, high impact blow. There's not a question as to whether or not or how you get this kind of head trauma. In other words, it's beyond controversy. You can't get this kind of head trauma from bumping your head on the door back here, or you can't get this kind of head trauma because you have weak bones. You can't get this kind of head trauma because you have some rare childhood disorder like Pageant's disease or Alagille disease or whatever it was that was brought up. Okay, rare childhood disorders, bone diseases, all these other things. None of those things will cause the trauma that this child suffered. To get this kind of trauma, it is an undisputed fact that it must be a direct, high impact blow. The time frame between the trauma and this child's death, this child's appearance at the emergency room and subsequent death, is also not reasonably in dispute in this case. None of these doctors who testified even allow for the possibility that this child's injuries were suffered the day before or the night before or even 3 or 4 or 5 hours before. They certainly weren't built up over time. It wasn't that he had a partial occipital and parietal skull fracture, with a massive hematoma at the back of his head and 3 or 4 other brain bleeds across his head, and that they just built up over some period of weeks. That's not what happened. The high impact trauma that this child suffered would immediately, according to Dr. Busman, very quickly, 30 to 60 minutes at the most, result in essentially a full onset of symptoms. Dr. Olick said there is 0% chance of normal behavior from the time of impact forward. What are the chances? May I ask, what are the chances? What are the chances that this child could have sustained this blow and behaved normally for any period of time? And the answer was there is a 0% chance of that. Dr. Clark makes it 3 for 3. The time frame that Dr. Clark establishes is this. He says that at a minimum, initial symptoms like drooling, staggering, vomiting would have appeared very quickly, within seconds to minutes after the impact. He said, in his mind, you probably would be in terms of the initial onset of symptoms. In his mind, it's probably more like seconds than minutes before the symptoms begin. Those facts have been established, ladies and gentlemen, by the evidence that you heard in this courtroom. Okay, you don't have to Google it. Okay, you don't have to have a discussion about what happened, when you were a child or when somebody else was a child or those kinds of things. You don't have to talk about what people in the medical community really think. Okay, we're not talking about vaccines or something where some people say it's this issue, you should take them and some people say you shouldn't and all that. We are talking about medical facts as to which there is no disagreement. That brings you to this point. The question for you to answer as a jury is this: who could have caused the trauma that killed this baby within the time frame that it had to have occurred? Okay? No telling. In any number of things, any number of people, any number of circumstances could certainly have caused severe trauma to this child at some point in time. But that's not really the question. The question is, who could have caused this trauma within the time frame that you have available? There's an answer to that question. From 8:00 p.m. Saturday night, when we were in Albany, Georgia, on January 13th, 2024, until about 12:30 Sunday afternoon, January 14th, okay, for that whole time period, there was only one person who was ever alone with this child. There was one person who was ever alone with it for any period of time during that 16 and a half hours. You know who that was? That person was Trinity Poague. Not only that, ladies and gentlemen, when you focus on this time period and you reduce it down to the time of the time frame that the doctors talked about, the time immediately prior to the onset of the symptoms, the answer becomes clearer. One person was alone with JD during the time immediately before his symptoms appeared. That one person was Trinity Poague. At 11:55 a.m. on Sunday, JD Angelus was a healthy little boy. By 12:30 p.m., he was in a literal death countdown. It wasn't a question anymore as to whether or not he might live. It wasn't a question anymore as to whether he could be saved. It wasn't a question anymore as to whether he would ever be able to grow up. By 12:30 p.m., at 12:30 p.m., he was dying. There were symptoms that appeared during this time frame that appeared when Julian Williams, Jay Williams, when he pulled up to the dorm and he got out of his car, he went inside to pick up that child. Actually went inside to put down the pizza and the drinks because he thought they were going to have lunch. But when he went in and he picked up that child, there were immediate symptoms that the child was suffering right then. The child was essentially unconscious. Okay. The testimony is that his head was limp, that he couldn't hold his head up, that his body was limp, that his head was bobbling around. He was nauseated. Before he got to the car, or as he was getting into the car, the child threw up all over his daddy. He was draining CSF, cerebral spinal fluid. Okay, the fluid that circles your brain, that encircles your brain, that helps protect you from impacts, that helps protect your brain from shock, from harm. Okay, that fluid, by the time he got to the hospital, was literally coming out of his nose and his mouth. It was no longer contained here where it's supposed to be. It was here because of the head injury he had suffered. He was in cardiac or respiratory, cardiac and respiratory arrest at that time. When he got to the hospital, he wasn't breathing and he didn't have a pulse. Those symptoms, when you go back to the time frame that the doctors established, those symptoms would have had the impact that caused them, the impact that caused those symptoms would have had to have occurred within minutes before the child presented at the hospital. During those 35 minutes that we're talking about, okay, these 35 minutes right here, 11:55 to 12:30, during those 35 minutes, one person and only one person was alone with that child. Trinity Poague. To think about some of this, ladies and gentlemen, you have a circumstance where you have two people in a room. We see this in cases that get presented. I mean, I guess prosecutors everywhere see it at some point or another. You have two people in a room. One of them ends up dead. There's a fight. One of them ends up dead. Okay, you would think that's an easy case, right? Like you have two people, one's dead. Now we know who did it. Okay? But those aren't typically easy cases. And the reason they're not easy cases is because the person who is alive says, it wasn't my fault. It wasn't my fault. He attacked me. He threatened me. He did this. He did that. I was fighting for my life. Or he angered me so badly that I didn't really have a choice. I was overcome by the emotion of the moment, so it should be voluntary manslaughter or something like that. Okay. So there's a myriad of issues that sort of layer on top of each other when you have two people in a room. Except in this circumstance, okay? Because the two people in the room during those 35 minutes were J.D. Angelus and the defendant. Those are the two people who were in there. There's not an argument that can potentially, possibly, in this universe or beyond, there's no argument that can be made that it was caused by the child, that the child, was aggressive, that the child was the initial aggressor, that the child, attacked her and she had to defend herself. Okay, so it makes the two people in a room situation, instead of it being a hard case anymore, it becomes an easy one. I'm about to wrap up here in just a moment. Sit down and turn over the podium to Mr. Gamble. But I want you to think about something, okay? As you listen to him nitpick the evidence, and you heard the examination, you heard opening statements, you heard the examination of various witnesses, and so you already know it's coming. But as you hear him nitpick the evidence, I want you to keep this question in the back of your mind. What do any of these things really have to do with the death of J.D. Angelus? Did poor parenting, missing well baby doctor appointments, misusing a car seat, did those things kill this child? No, those things didn't kill this child. Would testing some dirty diaper that came out of the dumpster or testing the vomit that was on Jay Williams' shirt and jacket, with testing those things, with interviewing some people in Colquitt, 50 miles or 75 miles away from, not it's more than 50, right? Like 75, 80 miles away from where this happened. We're going down to Colquitt and interviewing some people. Would that put somebody else in the room with Trinity Poague and the baby? Would that have put somebody else in a position to inflict this trauma? No, those tests, those things, you're not going to get that. Did a bottle of rum or a dispute or a fight over social media passwords kill that child? No. What killed that child was beyond dispute. It was a massive, tremendous blow to the back of his head that cracked his skull from here to here. So, you know, there's a smoke and mirror show coming, though. I promise you. There's a smoke and mirror show coming. And yeah, I was thinking about this in terms of like, how do you see through smoke? Okay, how do you clear the smoke? Right? Firemen, okay, there's a house on fire. Firemen go in and there's smoke everywhere. You know, they have to get through. They have to navigate through. You know, the smoke will kill them. I mean, if you just breathe it in, it'll kill you. You know, if you just accept it, if you just let it be there, if you don't fight against the smoke, it'll kill you. So what they do is they put on goggles, you know, and a face mask, you know, with a breathing apparatus and a breathing tank so they can navigate their way through the smoke until it clears and they can get to whatever it is they're trying to accomplish. That question, ladies and gentlemen, that question is that provides your goggles. Okay? That provides your breathing apparatus for getting through and seeing through the smoke that's coming. That girl killed that little boy. She killed that little boy. She cracked his skull out of anger, out of malice. We'll talk about all that later. She killed that little boy. She's the only person who could possibly have done it in the time frame in which it had to have occurred. Don't let these other things that don't have anything to do with the answer to that question, who killed J.D. Angeles? Don't let these other things cloud your vision and fog your mind. Thank you.
Thank you, Mr. Lamb. I'll let the jury step back in the jury room while the attorneys switch over their computers and such, and go ahead and take the stuff. We'll be back in 10 minutes. You good? All right, let's bring the jury back in. All right, Mr. Gamble.
Good morning, ladies and gentlemen. This will be the last time that I have an opportunity to speak with you. I have as many as 2 hours to speak, and I can assure you it won't be that long. I'm sure you'll be glad that it will not be. But what I have to say is important, because some of the things that the district attorney said just a moment ago, I'm not going to try to address that particularly, except one thing he said was that this is an easy case. And when I first came before you, I told you this was a case in which the state had a case that was filled with suspicion, but empty on evidence. And then this is exactly what I mean Would the state consider this an easy case that did not require an investigation, did not require much to be done because they were so sure of who they thought it was that was responsible, they failed miserably in every phase of the investigation otherwise? And if you look at the evidence, the question that was put on the screen about whether or not any of this has to do with the death of the child, this is not a case about whether or not the child died. We all know that. If that is what the state needs to prove, they have done that. And we concede that. That is not what this case is about. This case is about the state of Georgia accusing this young lady of a very serious crime of murder. And when the state makes a claim like that against someone, it is their sworn duty to prove it. And not just a little bit, but prove it beyond a reasonable doubt. That meaning that if there's any other reasonable explanation for what could have happened, any at all in your mind, you cannot come back with a guilty verdict. Now let's look at what we have in this case. And I'm going to go through several things. You got to imagine, I'm having to unwind quite a bit of evidence that's come through these last 4 or 5 days. But I'm going to try to take you through, not piece by piece who testified, but about certain things that matter. And the first one is, and a very important one is, that Agent Gibson came and testified. You remember, he is the person who said he is a crime scene specialist. He also has special training in crime scene preservation. He said he was told to go to a particular location where they believed the crime scene occurred. That would be the dorm room at the Oaks of Trinity Poague, where also Mr. Williams had been staying and the child. Now we know when he went there that really quickly after arrival at the hospital, an officer was posted at the door and it was taped off and someone stayed there. And so no one came back to that room after Mr. Williams and Ms. Poague left that room. We know it, one, because it was roped off and had an officer there, but also they got video. So we know if someone had come through in that dorm and tried to mess with anything from the time they left until the investigator got there. That's not possible. The investigator says that's right. So we don't have a question about, has there been a cleanup in this room? Has there been some tampering in this room? Nothing has happened in this room except the people left and they left it in whatever condition it was in at the time they left in a hurry to go to the hospital. And what did he tell you about his investigation? He said he took photographs of everything that he saw in each room because they like to show the setup of each room to begin with and let you know everything that's there. And then his secondary purpose and most important purpose was to gather any evidence that he felt was important to the case that could be used in this case to prosecute the case, whether it be against Ms. Poague, whether it be against Mr. Williams, whether it be against some third party, who knows, but to gather that evidence. And I asked him at the conclusion of questioning him, isn't it true that you did not obtain a single piece of evidence that was any use to you in this case? And he said, yes, that is true. Not one thing. I asked him, did you find any blood in that dorm room anywhere in that location? And that was it. His answer was no. Did you collect any type of human fluid that you thought would have been beneficial to tell you something? He said, no. I said, did you find any type of weapon in that room that might have been used, any kind of instrument that could have been used to cause blunt force trauma? Did you find a bat? Did you find a paddle? Did you find a statue that's sitting in the room that might be used? And his answer was, no. I found nothing that I think could use as a weapon. I asked him, did you find any place in that room or those couple of rooms where it looked like someone could have hit, an arm of a chair sitting out or a high countertop that might have a sharp edge, anything that looked like it could have been a child pounded into? Did you find anything that would have drawn your attention where you got evidence? He said, no. So what about the walls? Did you look at the walls to see? You would look at that. Yes, I would. Did you see anything? His answer, no. So we know that the state claims they have a crime scene, but a crime scene in which they have obtained zero evidence from. I'm not talking about a little evidence, zero, unless you believe Agent Ford, I think, said they did get a receipt from Walmart to prove they went to Walmart to buy the drinks. I'll give them that. That's it. Nothing of evidentiary value from a supposed crime scene. Now remember, they said this is a violent, massive force injury. Yet there's no evidence within that room of anything that occurred like that. And I remember I asked the agent, I said, well, have you ever heard of luminol? A lot of people I know have heard of luminol. Luminol is used to spray it across the room in case you don't see blood evidence. But just because you don't see it doesn't mean it's been cleaned up or it's only a small spot and you can't see it with the naked eye. Spray it with luminol, turn the lights down, turn on a certain light, and if there's any particular speck of blood, it'll light up. And I asked, did he do that? And he said, no, he didn't do that. He didn't offer an explanation why. He just didn't do that. It is inconceivable that someone individually, intentionally, did harm to this child in that way, and it didn't leave some type of forensic evidence in that room. And remember, you also told the child supposedly was throwing up on the way out of the room. There was no throw up coming out of the room into the hallway. No evidence The state is required to provide evidence. A defendant comes into a courtroom under the law cloaked in innocence, and it does not be removed from the defendant from the time they enter until they leave, unless some actual evidence comes in that can disprove that innocence beyond a reasonable doubt. But that crime technician, the one that's charged with collecting evidence, has collected nothing. So we don't know if that's a crime scene or not. We didn't get any evidence from him if it is. And we also know when I interviewed and questioned most of the arresting officers and GBI agents, anyone that was involved in this case, the autopsy people, all of them, we do know that the child suffered from blunt force trauma. We know that. But not a single person that I asked, number one, I asked each one, can you say, based upon what you saw, who did that? And the response for each of those persons is, no, I can't. I can't tell you from what I'm looking at. From what I observed and what evidence I had in front of me, I could not tell you. I could not say, yeah, I can tell you so-and-so did it. I can't tell you that I took ballistics from a gun. I can show it matches John Brown's gun. No. I can't tell you I found a weapon that was owned by somebody and now it's been used. And more importantly, I can't look at the body and tell you of a single mark that shows there's anything been done to it other than it has blunt force trauma, but not in a sense of you can see a paddle mark or a baseball mark or something that says someone did this to this child individually. They have none of that. So they don't know who, but they also don't know how. I asked the autopsy people. I asked Agent Ford. I asked every one of them. You know, how? What happened? Well, they've got some theories. Maybe this, maybe that. I don't know. We just know the child had significant injury. So now we don't know where the crime scene is. We don't know necessarily who did it. And we don't know how they did it. We don't have any type of weapon. We don't have any type of instrument that supposedly caused it. And you're left with some speculation of, well, could it have been just the hands of someone, just the person themselves? Could they have done that themselves? And somehow grab him, somehow punch him? Trinity Poague have done that. She grabbed a child and done that with her hands. Well, you would think that that's a possibility that the GBI would have looked at her hands, photographed her hands, would have looked to see if there was any signs that she used her hands. Because remember again, this is a violent force, blunt force trauma. She used her hands to cause that, and you talk to her within a few hours of it, and you look at those hands, it's going to show. Whether they're going to show redness from blows, whether they're going to show scratching, whatever it may be. And it took quite a bit of pressure, of course, according to Dr. Clark and some of the others that testified. And we also know Mr. Williams was around the child. Who's more able to use great force to cause injury? Who knows who caused injury? But if there is injury, we do know from Mr. Williams, nobody looked at his hands either. They didn't do anything to check that. And they didn't do that because they weren't going to check on Mr. Williams anyway. Because they were already down the rabbit trail they went down to begin with. That Trinity Poague is guilty and we don't need to look at any other evidence. Now you know that because I talked to Agent Ford, and I asked her about what their investigation do. We know that she talked to everybody that she knew in that dorm or had agents with her do so, interview them all, try to find out what they know. She got a phone. She got a phone of Mr. Williams. She did a few other things. She talked to different people. Well, then when I asked her about what efforts she made to try to find out anything about Mr. Williams or his sister, Ashante Burr, what did they tell me? And the reason I asked that before I go any further, remember I asked that agent, I said, when you have child abuse cases, isn't it true that sometimes or often you find that a child has had injuries before the situation that leads to their death? They kind of show they've been abused in the past, but now it's occurred. And she said, well, not all the time. And I said, but sometime, right? And she said, yes. And I said, isn't it important to then look, to try to see, to try to find out if that's the case? Now she discounted and said, no. Why did she say no? Because we already had a dead child here. I know it was in that dorm room. I don't need to look anywhere else. That's what she told me. I don't need to look anywhere else because I know where it happened. That's it. I don't need to look. I said, did you go to the house where the child lived and at least look at the house? No. I said, you wouldn't even know how to get there. Right now, if I wanted you to take me to where the child lived, and the answer is no, she wouldn't. Not even looking to see what type of condition was she living in. I don't know. No one knows. They didn't investigate it. Did they talk to any neighbors to see anything about the relationships going on? No. Did they talk to anybody that he worked with? No. Did they go to his workplace? No. Did they make any effort to find out? No. Because they'd already gone down that trail. And they decided at that point that this is the story we'll tell. And you'll see, and I'm going to talk about this in a little bit, about the testimony being shaped to make sure it fits over here. And struggle and fight no matter what to keep it there. Because that's what they decided early on, and they don't want to break away from that. But now you have a case, you got no evidence. None whatsoever about how the blunt trauma was occurring. You don't know for sure where it occurred. You don't know who did it, but they say it's an easy case. They say now we just got to look at it and we should be fine. But you know, maybe the most important witness that came in this courtroom was the one that's not tied up in connection with everyone. That's Dr. Buzzard. You know, the rest of these folks, they got some allegiance one way or another. GBI can say what they want to. Dr. Clark been working for GBI forever. Yeah, he's going to testify for the GBI, and you can bet your bottom dollar he's going to support whatever side he came in the court to testify about. He's not going to break off that. And you got these law enforcement agents, they've already gone down the rabbit trail. They decided what they know. They're not going to break off. But Dr. Buzzman didn't have to be in this case, didn't want to be in the case. He had one duty and one thing he had to do. And that was he was an ER doctor, and he had to try to give some type of treatment for this child and see if he could save it. That was it. And then he got called to come testify. And he had to do that. I'm sure he didn't want to. As you could probably see, at least somewhat, he wasn't that comfortable in testifying, but he testified. So you can bet he was trying to be truthful about that. And he told you some things that were extremely important. And one of the things that, as important as anything, I believe it's exhibit number, let me make sure I got the right exhibit here. Exhibit 26 is medical record from the treatment he gave the child when he came to the emergency room and all that happened. And that record's already been introduced. This is an authentic record. You're going to get it back with you. You can look at all of it. And it's got some pretty important stuff that's contained in it. The most important stuff that's contained in it. If you look at that document, I'm going to ask you that you do when you get the chance at the end of this trial, you're going to see that there are numbered pages. There's two sections of numbered pages. You first look in, there's just a bunch of preliminary stuff with no numbers on it, maybe 20 pages worth, 15 or 20. Then you'll come up with pages 1 through 39. Well, in that section of 1 through 29 on page 23, you'll need to look at. And then you'll see a second section of 1 through 28. And on that section, you need to look at page 20 and 21 of those. Why do you need to look at those? Because those medical records on 3 separate occasions say within the record that the father presents bedside and states the child fell around 5 minutes prior to arrival. Why is that important? First of all, we know from Dr. Buzzard that the only person bedside was the father. The girlfriend, Trinity Poague, was not there yet. So the only person, it's not a mix-up that they said he told it. We know that because it's in this record. Now, what was interesting about that, did you see how the state struggled so hard when they got back up to pull that out of the record? To say, well, didn't that get entered a few hours later? I mean, that didn't happen right away. Trying to insinuate that maybe some mistake was made. Maybe that's not really what got said. On. And Buzzman, you can see he was most confused. Why is that happening? But I'll tell you why that's happening. Because they didn't like what Buzzman had to say, and they didn't like what he had to say because it's a lot more than just the father coming in with a story that we know is not true. We know that the child didn't fall 5 minutes prior, don't think he did. Or if he did, maybe the father knew it and we didn't know it. But they try to then claim that maybe Miss Poague had told him that, and that's why he told the doctor that. Remember when I got Agent Ford up and started asking her about the interview she did with Mr. Williams? But before I put her up, I asked Mr. Williams, did you tell the agent when she first interviewed you what you believe happened to cause the injury? He said, first interview, yes, I did. Second interview, I said, did you tell her? Yes, I did. And I put the agent up and asked her, can you tell me, here's your summary. If you look at it, do you have it from the first interview that first occurred when you got there with Mr. Williams? Yes, I do have it. It's 10 or 12 pages long. Okay. Can you turn to a certain page there and tell me, if you're looking at that, tell me that anywhere do you see where Mr. Williams says what he thinks caused this injury? She said it's not there. In fact, what she read from that report was him saying that he came back to the room and asked Miss Poague what happened, and she said, I do not know. And then it said nothing else in the report. Now, first, the agent wants to avoid that too. She doesn't like that. She's protecting her story now, trying to make sure that we got the blame for Trinity. That doesn't fit the pattern. So she said, well, it may be in the report somewhere else. And what I told her, we got time. Read your report. Go through it. When you get through, let me know if you find it. Well, we sat here a few minutes, 5 or 10, but guess what? She finally said, I've looked. And I said, you find it? She said, no. Well, then here came the real squirm. Let's say maybe I just didn't put it in the report. He may have told me I just didn't put it in the report. That's interesting. You've got a trained GI that is taught that anything of importance will be put in a summary report to make certain that you're preserving that. We know that. We've heard testimony about that to some degree. But yet, someone tells them because they believe of what could have led to the injury to the child, and they don't put it in the report. But maybe they got told and forgot. And she says that on the first one. Well, the second report, I asked her the same litany of questions, said, what did he tell you there? And he said in that report, absolutely, he did not know what happened. He didn't say, but my girlfriend told me something. He didn't say that I know something. He said it didn't happen. So we know when he went to that hospital, no one had told him anything about a fall. That came from his idea. That came from his mind. Now, if he got interviewed by the GBI and he knew it, you can bet your bottom dollar in that only an hour or two after all this occurred, he would have said, yeah, the girlfriend said this. So we know that came from him. But we also know he didn't just tell the hospital that. Lieutenant Allen told us he came up when it was going on, remember? He saw him come into the emergency room. He saw him standing in the doorway watching while they were doing the workup. He pulled him back and talked to him and asked him what happened. And guess what he said he told him? That my son just fell face down a few minutes ago. Twice he's told that version. Twice he's told a different version to the GBI. And, if you really get down to it, looking at some of the questions for Mr. Williams, let's talk a little further. Remember when he got on the stand, he told those two things that it seems pretty apparent that maybe they weren't exactly on the up and up, what he was saying. Well, let's get to the third one. I asked him about being interviewed the third time. And the third time was important to me, maybe more than some other people, but I wanted to know at the time that he was interviewed, did the GBI agent allow his sister to come in and be interviewed with him in concert? And he said, well, yes, she came in, but when she came in, I left. I said, so you're saying if they asked her any questions, you left. And he first said we wasn't really asking questions, just looked at cell phone stuff. And then he said, no, she asked anything, I left the room. That's what he said. That's what he told us, right down that witness stand. What he said happened. And that's important because, remember, I was asking the agent earlier. I asked her when we were talking about Mr. Williams and Trinity Poague, I said, when they were at the hospital, did you just interview them together? I mean, they were already there together. She said, no. And I said, why not? She said, of course not. I wouldn't do that. Why? She said, well, it wouldn't make any sense. You would divide them up. I said, that's because it's protocol from the GBI. And she said, well, I wouldn't say it was necessarily protocol. I said, well, you think it's from training? And she said, well, I think training might have tell you to do that, but it's common sense that you would never put two people in together to interview them. I said, you wouldn't do that. No, I wouldn't do that. Well, now Mr. Williams talks about that. And I brought the agent up on the witness stand. And I asked her about it. And she got amnesia. She said at one point, it's been 2 years, I'm not sure. That's the standard we're using here for this case today? That it's been 2 years, so I'm not sure. So everyone that's come in from the police department, well, it's been 2 years. I mean, I'm not sure we can depend on anything if that's the case. It's been 2 years. I'm not sure. Are we to believe that agent hadn't reviewed her case file before she got here today? Or yesterday when she testified, or starting on Monday? She just came in after 2 years and just winged it? I bet you bottom dollar she'd already looked at everything. She didn't want to talk about that interview. And then, when we refreshed her memory, what did the interview show? Almost 20 minutes, interview by themselves, 40 minutes with him and his sister together. Now, why would it matter him and his sister? Well, it matters because him and his sister are who is keeping the child. We know from the evidence that the sister actually did more caretaking from the child than he did. She fought me about that some too. Well, I couldn't say that. He might have been some. Well, first of all, she can't say because he didn't do any investigation to determine. But we do know a few things. We know that he came to college at least twice a week, every week, and he came every weekend. And most of the time without his child. 4 days out of 7, he is not at home. He does not have his child. He has left the child with his sister. She is a caregiver of his child. Now, she is a caregiver of the child, and there is some suspicion of the alleged abuse. It would make a lot of sense to try to separate people and talk about that some, not put them together so they can be interviewed and get their stories together. But that is a sign of what was going on here, that we're not worried about them as being any suspect. We've already decided this case. We decided this case when January 14th came, by 5 o'clock in the afternoon, it was over. It may have been a couple more days before the arrest occurred, but the investigation had shut down, and nothing else was going to happen. You were just going to have to live with it, and too bad. Why? Because we got suspicion. We have suspicion. Well, it's a scary world out there if your government can all of a sudden just decide I'm a little suspicious and I can arrest you. It's a scary world. But you have that going on, but think about that sloppy investigation a little bit more. It's not just that problem. Remember when I asked the crime scene specialist about the dirty diaper? Now, he already knew that was coming up because we had filed a motion to ask to test the dirty diaper. We wanted to see if it had blood in it. And I've already asked Dr. Busman about it, and he said normally he wasn't sure that you'd have blood in your system from abuse, but I got to ask, but you could have some trauma at times that causes you to have blood in your bowel system. Can you not? And he said, yeah, you could. I don't think the injury that's caused his death would have caused that, but it could be from trauma. It doesn't take a genius to figure if somebody punches you hard right in this area that you might end up bleeding from that area through your system. Doesn't take a genius to figure when you hear about boxers when they've been finished a hard 12-round fight that sometimes they bleed out the rear end from it for days on end. It doesn't take a genius to know that you got trauma in here, that you will have blood coming through, and it takes time. I asked Dr. Husband, how long? And he said, well, you know, you can't really say because obviously people's systems work different. A few hours to maybe a day or more. What does that mean? Well, it means there was blood in that diaper. We know a few things. It did not come off of that child on the day the child was taken to the hospital. The child had on a diaper different that they took off of that child at the hospital. There are pictures of that. So it was previous to the child going into the particular situation that led to the hospital. And probably many hours passed or even the day passed back. If it's many hours back, whatever had happened to cause that cannot have happened at the hand of Trinity Poague. Because we have a very short window of time you can claim Trinity Poague did anything, which would be from 10 o'clock or 10:15 on Saturday night until 12 o'clock on Sunday, about 14 hours. That's the only time period she was around the child, and that within a week or so. Well, why is that important? I mean, you say, well, that's still not what caused the blunt force trauma. It's not. If you find that to be some abuse that caused that, it certainly would make you start looking a little further as to who might have done it. But if you choose not to investigate it, and worse than that, throw it away. So that this girl right here has no chance to defend it because the test that could have been run cannot be run because they threw it away when they knew it was a test they could run, and he got on the stand and tried to make like he didn't know that. I don't know anything about a fecal test. I've never heard of being able to test it to get for blood. I asked if you ever heard of the test, and he says, oh, no, I've never heard of it. And then he starts realizing, boy, that's going to be trouble, so what does he say? Well, I do keep a test for myself, and I can test for blood. If I'd have seen blood, I'd test it. He hadn't said anything about that whole time I've been asking him. All of a sudden, he pops that one up, but said, I didn't see blood in that diaper. Now, here's where Dr. Busman really comes in really important. Why he's one of the most important witnesses. Dr. Busman had no idea about the diaper. You could tell that when I asked him. I told him before I asked, you're going to find these questions a little bit weird or something to that effect. You know, I've been going a path that you may not understand. And I asked him about those diapers. And I asked him if he had experience with blood and fecal matter. He said, yeah. Oh, yeah. I said, you probably tested it. Yes. Is there a test? Oh, yeah. So hemocoat test. Easy. You know, it's done. I said, is it done quite frequently? He said, well, I don't know about frequently. I said, but yeah, you've done it more than a few times. And he said, yes. I said, if you see what you believe may be blood or suspect it, do you run? Yeah. He said, there's two ways I do it. Sometimes you can just see blood. You know it's blood. Other times you look and you say, well, maybe I better test it. And I said, so you can observe it, yes. And then, if you will, put up that diaper number 2. I showed him this photograph right here that you're going to be able to take back with you to the jury room. I showed him this photograph that I'm talking about, that he had never seen, had no idea about it. And my first question was, Dr. Busman, looking at that photograph, does there appear to be blood in the diaper? And he said, yes. I'd say probably so. Now, yes, that sent the state back scrambling again, where they tried to rehabilitate that answer and say, but yeah, it could have been something else. And he finally said, well, yeah, maybe like if there was dye in some food, it might have caused the discoloration. But in his opinion, just eyeballing it, yes, that diaper seems to indicate. You see right there on that screen, blood within it. He said, your crime scene technician didn't think that. Now, you can decide which one you want to believe. That's your job. The credibility issue of which one should be believed. Dr. Busman, who's done tests many, many times to test for blood, or this agent that decided to tell you all of a sudden that wasn't worthwhile. And it's interesting to note that diaper was not unfolded when he got it out of the trash. It was in a ball. That was the first exhibit 1. You'll see those diapers together. He took a picture of that, and then he unfolded them to take pictures. So you know that he knew that might be evidence. There's no reason to open them up and take a picture. And yet, after he got them, and once he saw what it looked like, he just chucked it back in the trash and left us with no way to test it. He left us with no way to test it. Oh, he doesn't care about what Trinity Poague has to say. He doesn't care about that at all because that doesn't fit his case. That wouldn't help him prove his case. That would hurt his case. Chunk it away. Chunk it away. It's inconceivable that was done. The crime technician tried to make like one he doesn't believe. You can take it down now. He does not believe that it is blood in that diaper or number 2 that should be tested. Because if it was tested, it would show, obviously, there was some issue going on with the child. Now, the other things could be going on. The child could have colon cancer, which would be almost unheard of for a 1.5-year-old child. Could have some type of ulcer, again, be extremely unusual for a child that age. If that child that age is bleeding, other than right around the very bottom of the bottom where it might have some kind of irritation, it came from trauma. If it came from trauma, and we came in the courtroom and show you that, well, then you really got to wonder, why are we not looking? Why are we not looking a little bit further? Now let's talk back a little bit about the statements that there's no one that's been alone with the child, with Trinity Poague. No. There's 2 people been alone beyond Trinity Poague with a child. Mr. Williams was alone with the child for a period of time. I'll talk about that in a second. And more importantly, the child itself was alone for a long period of time as well. Now, you may remember the testimony of Mr. Williams when I had him on the stand on the day of, the morning when this all erupted. I was going through a litany to try to determine what was he doing and what happened. He said they got up in the morning. He didn't know the exact time. Nobody really gave me a time, but we do know he laid on the bed, and he said he put the child on his chest, and he also said at that time he had ordered the pizza that you know that he went to get. We've got proof of that. Well, you can assume then from that, we don't have concrete evidence of what it is, that he must have ordered the food at some time getting toward the time he would normally eat. In other words, it's unlikely it was 8 o'clock in the morning he ordered the pizza. But regardless, he orders the pizza, and once he orders the pizza, they did not eat the pizza right now, go get the pizza right away. He told us that he got up after being there with the child for a little bit, after having already ordered the pizza, and I'm assuming he's giving enough time for the pizza to be made, so he didn't want to just leave right away. He and Trinity Poague got up to the shower together. And that's important in itself, together, because we know from the text messages you're going to see that are going to be introduced into evidence. One stream was to Miss Poague's roommate, where she's talking about in one sense on the Saturday night that she had told Mr. Williams, I'm through. He wanted him to go home that night, but he wouldn't. And she said, but I'm going to go ahead and let him spend the night with JD, but she wants him to leave. It's over. I'll be the first to tell you, we've already heard a bunch of evidence that it was a on again, off again, I'm breaking up, I'm getting back together thing. And so I don't put a lot of stock to I'm broken up and necessarily saying that it was over. But it could have been what was going on. I do know that Mr. Williams had been drinking the night before. He says only a glass or two after he got there with the child. Questionable whether that's true. We know that we have a bottle of liquor that only has about that much in it that he left in the dorm room. And we know Trinity Poague didn't drink it because he admitted she doesn't drink rum and wouldn't have, and it was his rum. But he tried to say that that got drunk at some other time. We don't know how much he did have to drink, but that night we know he went to sleep before everybody else. Saturday night, young man in bed by 10 o'clock already, and sound enough out that when the cry of a child that woke people up in the dorm at 1 o'clock or thereabout, he didn't wake up either night. So it's reasonable to believe he woke up hungover, not happy because his girlfriend is wanting to break up, and he might not have been in the best mood. Or it's also reasonable to assume that maybe the romantic breakup is being a makeup now because they're going to the shower. And if they go to the shower together, and they're young people, and they're making up, the chances are of them being in the shower for only 5 or 10 minutes is pretty slim. I mean, when you go in the shower with your mate, it tends to make the shower a little longer for young folks, sometimes even for old folks like me. But I can tell you, when they go in that shower, they didn't stay in there just 5 minutes or 10 minutes. They are showering together and most likely doing other things. I'm not judging that. I'm mad at them. But what does matter about that is a 1.5-year-old child is sitting in that little pink chair that y'all saw a picture of earlier and will get a chance to see when you go back to the jury room. And that little chair that sits there, it's not a danger to the child as far as I can tell of something happening in the chair. 1.5-year-old that by testimony by Miss Permott back in October, she was watching the child learning how to walk. He's toddler, so now he's got a few more months under his belt of walking. I don't know what in the world that child may have done while they're in the shower. I do know this. They were probably in the shower for more than 5 or 10 minutes, maybe 20 or 30 minutes, a pretty long time in the shower. They're in there. The child, I've got children, you got kids, my kids will never grow up. My 1.5-year-old boy, if you left him for a minute by himself without looking, he might be on top of a chandelier somewhere. He would climb and go and do all kinds of things. And who knows? Who knows what that child was doing right now? Who knows whether that child himself on that morning climbed up on something and fell back off of it? Who knows? But what we do know is that when the shower ended, Mr. Williams was the first one out of the shower. He testified to that right here and said he got out of the shower first, and Trinity Poague got out next. Now, you can say, now, well, so what? He got out, and immediately she got out. But he said something else. He said, I went and I was staying there with JD, and I was waiting on her to get out of the shower before I left. Well, that tells you two things. Waiting is a term you would use if you're taking a little time. Not I'm waiting that she's following me out of the shower. But secondly, he told us as soon as she got out of the shower, he waved to the child and immediately left, so we know he was fully dressed. He got out of the shower and got fully dressed before she came out of the shower. So there is a time period where he was the only one around this child. And there is a time period when the child was alone and no one was there. Now, I can't tell you that something happened when that child was by itself. I can't tell you there was something happened when Mr. Williams was there with the child. But I tell you one thing else. I can't tell you something didn't happen either. Because all we know is that was the situation. And so to say that there was no other opportunity for anyone, and the evidence they brought into court was if something had happened, it would take anywhere from seconds to a few minutes for it to show signs. Trinity Poague gets out of the shower, the child is in the chair, he scoops out, she's getting dressed, she's cleaning up around the house, doing the things you do. It might take a few minutes. You can see over in the chair a little way, but not think a whole lot about it. Finally, if you go over there in 10 minutes or 15 and go, uh-oh, what's going on? It's something that happened to the child, whether accidental or maybe worse. But you can't discount that. You can't say that's not a reasonable proposition of what could have happened, because it could have happened that way. And we don't know for sure. And we don't know because there's not been an investigation. There's not been anybody tried to push on those issues. They just said, we're just going to accept it for what it is. We see you got a child that's not alive, and we're going to blame it. Trinity Poague. That's what we're going to do. That's what they did. And, you'll see that Trinity, and I'll talk about this a little bit later, but Trinity told people at first when this first occurred, she had said that the child had fell off the bed. She had actually mentioned that the night before, talking to Mr. Hermont.
Objection.
I mean, not told, but said through text message.
Facts, not in.
Through text message, I'll tell you about it. Through the text message. She didn't tell in the sense of talking, but you'll see on the text message from Ms. Hermont where she said that the child had fell out of bed the night before. And you'll see that she said that then. And so then you have not only her statement that happened, but I brought two witnesses in to talk about they heard a baby crying sometime between midnight and 1 o'clock or so. Loud enough to wake them up. Now, these weren't even particularly favorable witnesses to me. They had some things to say that weren't all that favorable for Trinity Poague. But they were important witnesses because they established when she said something happened that night, it fell out of bed. Well, you got two witnesses that said, well, I'm right across the dorm, one straight across and one to the caddy corner, and I heard the baby crying enough to wake me up. They both said the baby would cry a lot of different times for various reasons, but this was enough to get their attention. So we also know that happened. Now, she did say when some of the records were shown, there was a claim, if you remember, Dr. Wright, or Reverend Wright, I should say, said that she claimed that the child was in distress and fell out of the chair. Talking about that little pink chair. Well, if you look at the pink chair, you'll be able to quickly see she fell out of the pink chair and nothing happened. I would suggest to you, and I believe that I asked him about it as well, that what she meant by that is when she noticed the child in distress, the child was slumping over, and it just sort of slumped out of the chair. That was not the cause of the injury. She was not presenting that to say it was caused by the child falling out of the chair. She was telling them, what do you know? Well, I came up, the child's in distress, and it fell out of the chair. She wasn't insinuating. There were two different things here. Two different things entirely. I had lots of questions I was asking about possibilities of falling out of the bed. And I know that some of the experts try to discount that to some extent and want to say, well, we're not talking about it. Time may not be right. I don't think that injury could occur. 40-inch bed is pretty high. 40 inches as high as my hips. You're talking about a small child that's 31 inches tall, falling onto a hard concrete floor. That child lands flat, bam, the back of its head, and have some significant injuries. But I asked Dr. Clark about it, and he was kind of waving around. But then I asked him, remember, about particular scientific journals and treatises. And he didn't know I was going to ask him about it. I didn't know that he would know what I was talking about. But I asked him if he was familiar with Mary Case, Dr. Mary Case. She's a forensic scientist out of St. Louis County's forensic department. I said, is she well known? Yes. Do you know her? Yes. And I said, how do you know her or whatever? And he said, oh, I just went to a seminar, a week-long seminar with her. I've been to two. You can tell. He valued her opinion. And I brought that up because I wanted to point out a fact that was contained within that particular literature. And there was a particular page I turned him to. And I'm going to read you about that page one more time because I think it's critically important. The paper was talking about accidents in which children had fallen from not particularly large heights, and it was severe enough that it killed them. And admittedly said it was rare. It didn't happen all the time, but from time to time, a fall would occur that would appear that wouldn't be enough to cause significant harm, but did. And the first case study said that a 4-month-old male child was taken to a children's hospital. They did a CT scan, and it came back normal. He would not eat or sleep well. He survived for 2 days. They would then decide to take him to see his pediatrician. He died on the way there. They said he fell out of an adult bed and struck the edge of the bedside table. So an adult bed, unless it's something really unusual, would not be even 40 inches tall. A second one said a child that was 21 months old male. He cried after he had fallen. He was able to be comforted. He vomited, but then put back to bed after he was through vomiting. They found him dead in the bed the next morning. He had fallen out of his own bed. A third one was a 7-year-old female who fell off of a 36-inch tall tree stump, and she hit the back of her head. She complained of headache and vomited several times. Over the next 12 hours, she's found dead the next morning. And then finally, a 10-year-old boy who had fallen off his bicycle, and he was found on the ground. He went to the emergency room. CT showed a fracture of the right temporal. Then it cuts off as to what happened, but he died. Now, these all involve subdural hemorrhages. Now, the expert, Dr. Clark, wanted to try to walk away from that some by saying, well, wait a minute, those deaths weren't caused by a fracture back here. They were fractures somewhere else in the skull, so that just sort of didn't count. But one of them did involve falling on the back of your head. But regardless of whether they were the exact same fracture, it's pretty good proof that time to time, a fall from not too high can cause significant injury. And if indeed that fall from the bed caused that, and sometimes it can't be discovered right away, and you looked at it, you see these examples, no one thought these children were in great danger. Two of them went to the doctor, hospital, and were given the clearance to go home, and they died. This young lady here, Trinity Poague, she's not a doctor. There was no real visible signs, even according to the doctor, to the officers that first looked at the child. That was not in a real heavy area of what might be considered harm, where you look at the child just visually and think something serious was wrong. In fact, even the autopsy doctor said, and the doctor at the scene of the ER said, you had to feel the back of the head to realize that he suffered any injury. If that child got injury out of bed at around midnight or later, it may have taken a few hours before it all of a sudden erupted and showed itself. Trinity Poague had no reason to think that was any serious injury. She would have no reason to. And she certainly would not have been the person that caused it. And if that's a possibility, and it certainly is a possibility, there's enough evidence to show that that most likely did happen when a child falling out of bed. That's reasonable doubt as well. You cannot say that Trinity Poague was the cause of it. And I know, ladies and gentlemen, that you've heard some other things that you may have questions about Trinity Poague's posting of certain text messages that are in evidence already. She was in an immature relationship at 18 years old with a 23-year-old man, and she made comments from time to time as they went back and forth with their up and down relationship that could have been said better. And she did say at times she did not like the child and those type of things. But never once has anyone said that they saw her in any way trying to in any way harm that child, including the father never said that. He never claimed that there was anything abusive going on. These were a matter of speech. It's much like if my wife were to go out shopping and come home and I thought she was buying a $100 coat, it was $1,000, I might call one of my friends and say, I could strangle my wife. She just bought a coat for $1,000. Do I mean I'm going to strangle my wife? Of course not. Poor language perhaps, but just simply talking, in this case, mostly to Miss Permont, who is her roommate, who is a person that she is very close with, who she discusses her relationship. In fact, you will see in this thread of information on the text messages, you will see where in parts of this, Miss Permont sort of agrees with her on stuff. He's talking about having trouble in State's Exhibit number 39, and she asked, is he sleeping with JD in your bed? And Trinity replies, probably. And she says, TRIN, that's so messed up. Make him get on the air mattress with his child. That's not your kid, and y'all aren't together. I know I told him after tonight he better not contact me. It's Trinity's reply. This is a conversation between Permont and Trinity. So we know a few things from just that little thread. First of all, Miss Permont's saying to her, you need to quit letting him just give the child to you while he goes and sleeps and does whatever he wants to do and won't tend to the child. It's his child. Tell him to come be responsible for getting him into bedtime and doing what needs to be done. So she knows that that's been an issue. And then secondly, officer a place to sleep. And she says in return, though, after the night, better not contact me, let you know it's on that downswing again. That's what I was talking about just a moment ago. And then there are conversations after that. But this is not proof at all of any type activity by Trinity Poague toward that child. You know, you don't have any evidence that Trinity Poague made any type of confession, which of course she did not. You don't have any evidence that she talked to some people after this event and has told them incriminating evidence somehow or another and they brought it into court. Again, you have no evidence that says she committed this crime. You have the suspicion that she committed this crime that is given to you by the district attorney and then by the state of Georgia without evidence to support it. Now, you also heard that she searched some items after she was at the hospital about skull fractures on her phone. And I want to be very clear so there's not any confusion about this. This is not a search that was done before the child had been injured. This is not a search that was done during the injury of the child. This is a search that was done after she was at the hospital and after Dr. Busman met with her and Mr. Williams and told them that the child that the child had a severe skull fracture and was likely not to survive. Now, at that point, you can look at this, and I'm going to tell you where to look on this as well, because I think it is very important that you see this as well. On those same documents, the one that's 1 through 39, the medical records, if you look at page 38 of 39, it has a colloquy that shows at 1:15 that afternoon, he spoke to the family to update the condition. That is when they meet and say, this is really serious. Trinity Poague, an hour or more later, and then 3 or 4 hours later, did search terms about skull fracture. What does that mean? And how can a child have a skull fracture? That's very logical to assume you would do that. If someone told me my child had a skull fracture, I've seen nothing happen to cause anything to injure to the head, I would want to know, how can that be possible? And I might even say to myself, well, I know he fell off the bed. That happened to the bed, but is it possible he fell off the bed and it caused it? I would search. That's what happened here. This is not, again, the way the prosecution wishes to portray it. They want to try to make it some nefarious, evil thing that was done. She did the thing that anybody would do. Check and try to find out what in the world does all this mean. Trinity Poague was 18 years old. She was living alone for the first time in her life at Georgia Southwestern College, and she'd been there one semester when all this happened. She came to the hospital after a traumatic event happened that she had no idea what was occurring. On a child that was in distress on things that she had nothing to do with and did not know what was occurring. And then found herself within an hour or two being interrogated by GBI agents, by police officers, all that you can imagine, and her trying to figure out what in the world is going on. Now, ladies and gentlemen, you've been sworn in to follow the law in this case, to make a decision on whether or not the state has a right to say that she committed a crime, a serious crime. And your duty is to hold the state to their duty, which is they must prove that case, each and every element, beyond a reasonable doubt. If any doubt exists whatsoever that is reasonable, you cannot convict. You cannot discount the possibility that Mr. Williams could have been responsible. You cannot discount the possibility that an accident happened to the child while they were showering. You cannot discount the possibility that the fall from a 40-inch bed caused injuries to this child. All of those are reasonable doubt. You cannot come back with a verdict otherwise. You know, this place that I'm in today, I've been practicing law now for longer than I sometimes want to admit. And I've had many a trial, but it never changes in one respect. When I'm in a courtroom, this is hallowed ground. Where I am at right now is the bedrock of what we do in this country. We're a country different than all other places, in that we require, when someone is accused of a crime, that it be brought before a jury to make a decision, and that the proof of it is not just, I think you did it, might do it, more likely you did it, but you must have solid, no question evidence beyond a reasonable doubt. It requires that be evidence. There's not been evidence at all. The state still doesn't know how it happened, where it happened, why it happened, who it happened, or even with what was used for it to happen. Do not make the mistake of allowing your emotions to be involved in this case so that you say, we must have a verdict some way because a tragedy occurred and I need a verdict. Do not, as I said in the opening of this case, in your rush to seek justice, do so on the cross of innocent blood of Trinity Poague, who has not had a thing to do with the injury that occurred to that child. It was a tragedy that occurred for reasons that I will not stand here and tell you I know the reason. But the interesting thing is, they don't know either. Oh, they know it's a death, they know it's blunt force, but for all the reasons I told you before, they do not know. I trust you when you go back to the jury room that you will consider the law, you will consider the evidence, or in this case, the lack thereof, and you will return the only just, the only righteous verdict that Trinity Poague is not guilty.
I'm going to give you a 15-minute recess. We'll come back at 12. Let's make it 12:10. 12:10. We'll come back at not 12:10. I'm sorry. 11:10. 11:10. We're clear on that. 15 minutes basically. Thank you.
But thank goodness we get to speed him up. Who is that? Okay. Oh, wow. So they are still currently deliberating, of course. Okay. Thank goodness we were able. Yeah, this is his sister. Yeah, and that's his new girlfriend, y'all.
Probably. I mean, we'll see how it's going. No, let me just deal with it. All right, Mr. Lamb, you can conclude your argument.
In the way back, probably just shows how old I am, which is old. In the 1980s, there was a movie called Scarface, and the guy was like a Cuban guy who would become a drug lord in Miami or whatever in the 1980s. And there's a scene in there where he gets caught, not for pushing drugs, but he gets caught for laundering money, like trading money for swapping it out with somebody else for percentage of the profit in order to account for all the millions and millions of dollars in cash that are coming in. And so he gets caught, his own video and all this, So he hires a lawyer, and the lawyer comes in and looks at him, and the guy says, I want my rights. I'm presumed innocent. I'm not going to. And the lawyer looks at him, and he says, under the law, he says, to be convicted, he says, the government has to prove that case beyond a reasonable doubt. And he says, and Tony, honey, baby, he says, I am an expert at creating that doubt. And he says, but it's awful hard to do when you're sitting there and there's no other explanation for you having $2 million in 20s rolled up in duffel bags. And that's sort of the situation that we're in here. I understand Mr. Campbell's a great lawyer. I mean, he is. He's an excellent lawyer, and he can find these things he created. And that's why, literally why, I ask you, so when you listen to this nitpick, wait for an answer to this question. What do these things really have to do with the death of this child. And we're going to talk about it. We're going to talk about the poor parenting and the dirty diaper and the vomit on the jacket and all of that as we get further in. But first, ladies and gentlemen, what I want to do is I want to talk to you about what the charges are and what I have to prove. Okay, these are the charges that are in the indictment. Okay, and I'm sort of starting actually. I think I'm starting kind of in reverse. I should go back and put them in the order of the indictment. But there's a reason that I wanted to do them this way, and that is that I wanted to start with what's kind of the underlying felony charges, which then go up the scale as you add other things. So aggravated battery, the state has to prove the defendant maliciously harmed the person by rendering a part of his body useless or seriously disfiguring a part of his body. Was the evidence in this case establishes that J.D. Angeli's brain was essentially rendered useless, that his liver was rendered useless, his liver was disfigured due to massive lacerations, and so forth. For first-degree child cruelty, the state has to show that the defendant maliciously caused cruel or excessive physical or mental pain to a child. Now, both of these charges include the phrase malice or the word maliciously. And the law, and this is what I think Judge Seisman was going to charge you with all of these things. That's the reason I'm putting them up now. And I think you may actually get a copy of the charge with it. And if you don't, if there becomes a question and you think, we need to be clear on this point of law, all you got to do is say, hey, Judge, can we get a recharge on this or that? And they'll come back and tell you this again. But malice is not necessarily ill will or hatred. It simply means an intent to cause pain without justification or excuse. Malice also means willfully, intentionally doing an act while aware of a strong possibility or strong likelihood that pain may result. If you pick up an 18-month-old baby and you slam him down on a piece of furniture or on the floor or against the wall, whatever, with the degree of force that's necessary to fracture this bone, with the degree of force, in a separate blow, with a degree of force that is sufficient to tear his liver practically in half, okay, then folks, that's malice. Because you can't do those things to anyone, particularly not to anyone, a child or anyone, without knowing that it is a strong likelihood that pain is going to result. So if you find Trinity Poague guilty of aggravated battery or cruelty to child in the first degree, and I submit to you that you should find her guilty of both of those charges. If you do, then that brings you to felony murder. And what felony murder is it says a person commits the crime of murder when in the commission of a felony, he causes the death of another human being with or without malice. Okay? So in other words, it's not a matter of did somebody intend to kill him? Was somebody aiming to kill him? Was it a specific, I'm going to, I've got an hour, I've got 30 minutes, I'm going to kill this baby right this minute. Kind of thing. Don't have to prove that, okay? Don't have to prove a specific intention or intent or desire to kill. All you have to prove is that the felony, the underlying felony was intentionally committed with the person knowing that it was likely to cause pain. And if you do, then that leads to the finding, I think, almost necessarily, I say I think, and not I think, but I don't. There's when you look at how do you analyze this, you find the felony, and then you look at this charge, which says that if a person dies in the commission of the felony, then that's murder. Well, that's exactly what happened here, and that circles back to where we were at the beginning of my first part, which is that the question is who caused the trauma that killed the baby within that time frame. That ultimately will answer those other questions, okay? Because if you know the answer to this question, then you know the answer to whether the defendant is guilty or not guilty of those other charges that have been brought. I fully understand, I respect, and I honor the burden that I come in here with, and the judge is going to charge you, and there's no question about it. Mr. Gamble argued it, and he's absolutely right. The defendant is presumed innocent, and that presumption carries with her throughout this whole trial. It carries it. She had it when she came in this courtroom. Okay, she has it when you go to the jury room. Okay, but when you look at the evidence and you find that the evidence is sufficient to overcome that presumption, when you find that the evidence is sufficient to show you beyond a reasonable doubt that she's guilty, then the presumption goes away. Until then, she certainly has the benefit of it. The state, the law says that nobody can be convicted of a crime unless the case is proven against them beyond a reasonable doubt. We have to prove all the elements of the indictment in order to do that. The evidence in this case is not it's not as complicated as Mr. Gamble wants you to think it is. It's actually fairly simple at this point. And that is, okay, we start on Saturday, January 13th. Jay Williams was in Cockwood. JD was with him. He had been up here. He'd been up here earlier in the week. He'd stayed here like Thursday night, Friday night. Okay, he stayed at her dorm or in a motel, whatever, at Hampton Inn Thursday night. This is his testimony. He stayed in a hotel there. She'd come over, and then Friday he was going to stay in the hotel again. And she came over, and when she came over that time, and she didn't want to stay. She said because they're breaking up. She's breaking up, right? So she wants to leave. She wants to go. She goes back to the campus, and when he doesn't come with her to the campus, she calls him or texts him and lies to him about having been in a car wreck. She lies, says I was in a wreck. And he told you that, of course, his reaction to that was he took off to the campus, to check on her, and she was in a wreck. She wanted to talk to him. And so it was sort of reverse stalking. Like I'm not, instead of following somebody, he's like, here, come here and follow me. And that's exactly what she did. And so on this day, the next day, January 13th, she's in Americus, he's in Colquitt. She wants to go to Chipotle in Albany. Okay, so she asked him to meet her there. He doesn't call and ask her out on a date. He's not planning on going anywhere, and that's what his testimony shows. The reason that he wasn't planning on going anywhere is because he was going to be home with his son, with JD, and nobody else was there. His sister wasn't there. Didn't have anybody else. He didn't trust anybody else to keep JD, and so he tells her, he says, I'll come, but I've got JD with me, and she says, well, come anyway. Just bring him with you. They get there, they eat dinner, they go to Sephora. She swaps the car seat from his car to her car because it says that to his testimony, she says that he would maybe give her a little time to spend some time with JD, while she's driving and work on building some kind of bridge or relationship with him, etc. So then she says she wants him to come back to Americus with her. And the car seat's in her car already. And he says, yeah, okay, I'll come back to Americus with you. Okay, so at this time, when they're in Albany, okay, this video it's one of the videos that was played. I mean, it's not a video, it's a screenshot of the video, okay? But this shows the child in the car, okay? This is when Jay Williams has left Colquitt and is coming to Albany, that this video is taken, okay? And he's wearing his little blackie Nike, his black Nike is what I'm trying to say, his black Nike hoodie and not hoodie, jacket and pants, his suit, tracksuit or whatever, which is the same thing that Jay Williams was wearing himself. He made reference to it that was they had matching outfits. Okay, this is what this child looked like. Okay, there's no bruise on this side of his face. There's no marks on this side of his face. His face isn't swollen or anything else. That's what he looked like when he's in Albany. Okay, now there are these claims that were made in opening statement. Okay, that have turned out to just simply not be true. Okay, in opening statement, the defense says that Jay was drinking when he met her in Albany, and she just couldn't send JD back to Colquitt with him. So that's why she took the child, and then she let them come to Americus with her because they wanted to go to Americus or Jay did. That's what you were told you would hear. There's no evidence that says that. There's no witness who testifies to those things that you were told you would hear. In fact, what happens is on January 13th, if you look, after she has asked him to drive from Albany to Americus, okay, before she's even back at the dorm, she texted Paris and she says, are you coming back? I got stuck with JD. Paris says, yeah, I'm coming back. And she says, he made me feel so bad because it's already late and JD is being so fussy. So he asked if they could stay. And ladies and gentlemen, there's just no actual evidence that is what happened. And in fact, it doesn't make any sense at all that he would have done that because if he's in Albany, he'd be closer to home than he would be to here. So on Saturday, then what happens is this. They get to the dorm, they go through the doors, and you saw the video from Georgia Southwestern. They go through the doors at 10:06. He testifies that he blows up the air mattress for Poague and JD to sleep on. Trinity Poague and the baby are going to sleep on the air mattress. And there's not a lot of explanation for why that is, but the context of some of the other messages that we'll get to later, and I think the testimony of Paris in this trial suggested that typically when JD was here, that he would sleep on the air mattress with Miss Poague. That night, Paris came to visit him. Okay, she wanted to see the baby. She left work on her lunch break. She came to see the baby. She says that when she saw him, he was perfectly okay. He didn't have any bruises. He didn't have any marks. He didn't have any tenderness or soreness. She picked him up. She hugged him. You know, they kind of played around, and he wasn't tender. He wasn't shy. Wasn't any of those things, okay, because he hadn't been harmed at this point. He doesn't have any bruises. He doesn't have any injuries. Jay Williams fell asleep on the bed watching TV. So let's take a pause here and figure at what's the baby's physical condition at this time, okay, which is 10:30, 11 o'clock on Saturday night. There's no evidence of bruising, pain, soreness, or any injury. The only thing that was said was he might not have been hungry. There was some allegation that he didn't eat much. Of course, Mr. Williams said the reason he didn't eat much at Albany or wherever was because he had eaten in Colquitt before he came up here. Then that night at 11:46, Ms. Poague texted Paris and says, "Is it okay if I watch TV in your room?" She says, "Yeah." "Why, are you all right?" She says, "Yeah, I need a break, a mental break. JD isn't asleep, and Jay is knocked out all over the bed, and I didn't want to play the TV." Is what she says there. So 11:46, she's asking Paris if she can go to the other room with JD. So it goes Sunday morning. This is Jay Williams' testimony. He woke up. They woke up. She had gotten in the bed with him off of the air mattress. They woke up. He said he woke up somewhere around 9, maybe something. Said she woke up like between 9 and 10, I think. Says that he picked up JD and he put him on the bed with them and he laid him on his chest for a little while and whatever. And then they got up to take a shower. Now, the allegation is that the statement from Mr. Gamble is that he says that they ordered the pizza before they got in the shower. The testimony, and you will recall it, of course, was that they had talked about ordering pizza at like 10 or 10:30, but hadn't done so. And then they ended up actually ordering pizza, a little while later. And whether it was before or after they got in the shower that they ordered the pizza, don't know, but it doesn't matter. Okay, he gets out of the shower, he gets dressed, he says goodbye to JD, he leaves to go to Walmart and Pizza Hut, and at the time he left, and at the time Trinity Poague got out of the shower and went back in the room, JD was in that pink chair watching Couturier, a kids show on TV, and had a Mountain Dew and some Fritos Twister chips. Okay, so when Jay Williams leaves at 11:55, what's the child's physical condition? Again, no evidence of bruising, pain, soreness, or any symptom of injury. He might not have been hungry. That didn't come out very clearly, but that's at his worst condition if you hear the evidence. Okay, he's gone from 11:55 to 12:30. When he's turning back into the parking lot, he got back-to-back calls from Poague. She didn't tell him that anything was wrong with the child. What she did was she called and hung up, and then he said, as he was parking, he was about to get out of the car, she calls back, and she's not talking to him. She hears him saying, JD, JD, JD. So he gets the pizza in the Walmart bags, and he goes into the college, into the dorm. You saw that on video as well. And if there's any portion of those that we can't send videos to the jury room because there's no way to play them back there. But if you should decide that you need to see them again, all you have to do is ask him, and we certainly, the court will make arrangements for that. So he goes in the room, she's holding the baby. He realizes that there's something wrong with the baby, and he did. He testified that he asked, what's wrong, and frankly didn't testify real clearly as to what she said in response to that. We said what's wrong, but he wasn't waiting around to find out. He put the pizza in the bags and put the pizza down, dropped the bags on the floor where they were, picked up the baby, and took off for his car, and he drove to Phoebe Sumter. At Phoebe Sumter, he went with JD. The nurse met him and put JD on a gurney, and then he followed them to a treatment room. Now, Alan testified. He says there's this thing that Mr. Gamble keeps making a big deal out of. Says that this note in the nurse's record. He says this note says that the child is limp and pale. That father present at bedside states child fell around 5 minutes prior to arrival. Okay, and that note has an event time of 12:36. Okay, so Mr. Gamble wants you to interpret that as meaning that is what he told her at that moment when he went in. That he was standing at the child's bed when he told him that. And because there's other things in this note that we know it's not exactly accurate. It's close, but it's not exactly accurate. Okay, the note says that the child is at ER and the front is taken to ER 16. From the front entrance of the ER, he is carried by his father, who was unresponsive. The father wasn't carrying the child anymore. He got met by a nurse after he came in the door, went to the front desk or whatever, past the front desk, got met by a nurse and put him on a gurney, and that's what the other evidence was that she heard. He followed them to the treatment room, but Alan says that he didn't go in the treatment room. He wasn't bedside. He can't go in there when they're doing CPR and they're intubating the child and doing all of those things. He remains outside the room, just outside the hall, in the hallway, and he does that. He does that because that's the only place that they let him go. So he's not bedside. Now, okay, by the time this note was written, he had been bedside. Okay, by the time this note is written, which wasn't actually entered until 8:04 p.m. By the time the note is written, he has been bedside. He was bedside when the child died. Dr. Busman told you that. He wasn't bedside when they were administering treatment, and he wasn't bedside giving a history. Okay, the note's written 8 hours later, and despite everyone's best efforts, okay, it's very hard to separate all of the story of events that happened over the course of just a little bit of time with regard to the treatment of this child. Also, okay, Mr. Gamble says he told them that 3 times. That note is in there 3 times that he said that. He didn't tell anybody anything 3 times. Okay. The note is a nursing note on page 21 of 28 of the second batch of numbered pages. It's a nursing note. Okay? It's simply copied into the record because there's the nursing notes, there's a code blue report, there's physician notes, there's other reports, and they get cross-copied and copied on top of each other, which is why when you ask for your own medical record somewhere, you get 200 or 300 pages, they want to charge you for, and you realize ultimately there's only 20 pages of it that really matter. Okay. And that's sort of the same thing here. The same records are copied over and over again because different people in different roles have to keep them. And then when we ask for all the records, we get them all packaged together. He didn't tell anybody anything 3 times at the hospital. And the hospital didn't write it down 3 times. It's one note that was written at 8 o'clock that night. Alan wants to talk to him. Alan said he was emotional, that he didn't want to talk to him there, and he didn't want him to keep standing there because he was upset. So Alan asked him to go out and walked outside with him. And Alan asked him to go outside, and he does. He told Alan, according to Alan, he told Alan that Poague had told him that JD had fallen out of a chair. Poague got there, and she told Alan that JD had fallen out of the chair. She specified it was one of those round beanbags, or at least he interpreted it as a round beanbag style chair. And she says he was eating chips and drinking juice, and she heard him fall over out of the chair. Not that he just simply slumped down, but she heard him fall over and hit the floor. Okay, that's what she tells Alan, not what Williams tells Alan. I mean, it's the same thing Williams told him, but it's not. But it's not his words; it's her words. Okay. There's a reality to what we do when people go back and you look at records and you look at notes and you look at reports, okay, from 2 years ago, and you ask people, you say, okay, I need you to remember line by line and word by word, second by second, minute by minute. Okay, I need you to tell me what did you say and what did they say next. And then we come into court and we have these prior statements, and we've got reams of interviews and records from hospitals and doctors and phones and everything else, and we say, did you say that? Yeah, I said that. And they know somebody knows they said it. They know they said it at some point back there. If you ask me, if I said it to this person, and then you ask me, did you say it to that person? Well, 2 years later, it might be really easy to say, yeah, that's what I told him too. Because it's kind of hard to delineate those things. And that's just the reality of the memory. Okay, that's the reality of the memory, whether you're in a courtroom or, you're sitting around, on Christmas Eve with your family, and you start talking about something and say, remember when so-and-so, and you realize that nobody there remembers it the same way you do. Okay, and you end up there, like you have, people that's like, no, it wasn't. That wasn't on Christmas. That was on Thanksgiving. And it wasn't that year. It was the year before. And so, the reality is that the only person who had information about what happened to this child was Trinity Poague. And she's the one who told Alan what Jay Williams testified to, okay, what Jay Williams testified to, which is different than what Allen testified to, no doubt. Okay, what he says is that she was there and she told Allen in his presence, and that's where he heard the chair story from. In any event, ladies and gentlemen, the evidence as a whole shows you that it's Poague who is promoting that story, not Allen. I'm sorry, not Jay Williams. I'll go ahead and address it now. I'll skip it later. He says, but ask him, did you tell Samantha Ford that you knew, did you tell her what happened? And he says, yeah, I told her. I told her what happened. I'm sure I told her what happened. And it's like, okay, well, what you tell, did you tell her he fell out of the chair? Yeah, I told him he fell out of the chair because that's what he told other people once he had heard it from her. But then he instead of getting the statement, the interview that Ford had done with Jay Williams, okay, what Mr. Gamble does is instead of showing the interview and saying, look, you want to refresh your memory about this, be sure that what you said. He doesn't do that. He's charging him with being able to have in his brain the knowledge of what he said in a 2-hour, I think it was an hour and 45-minute long interview on the day that his child died. Okay, so in the 8 hours following the time that Jay Williams found out that his baby was dead, he spends 4 of those 8 hours at the America's Police Department sitting in waiting rooms or interview rooms. He spends most of that 8 hours sitting there. He spends 4 of those hours being actively questioned by Agent Ford. Okay, so you may say, did you tell her that without showing him the interview, without showing him the statement, without letting him, look back over it and say, I don't know what let me see exactly what I said in that 2-hour interview. And Mr. Williams says, yeah, I told her he fell out of the chair because that's what he had been told, and that was the only information he had ever had about what happened to his child. He told Coroner Wright that Poague had told him that JD fell from a chair. But Poague also told Coroner Wright that JD fell out of the chair, that he was in a chair eating chips and then he was in distress and fell from the chair. She told Wright that Jay had been gone for 5 to 10 minutes at the time the fall occurred. That is the sum and substance of the evidence of the people who have testified in this trial, based on their memories, based on their reviews of records, etc. That is the sum and substance of what the direct evidence is about the events of that day. But it's not just direct evidence, ladies and gentlemen, that you make decisions on. And the court is going to talk to you about circumstantial evidence. Okay. What circumstantial evidence is proof of facts or circumstances, actually by direct evidence, from which you can infer other facts that are reasonable and justified in light of your experience. Sort of like if the child gets his head bashed in and his liver busted 20, 30, 15, 5, 35, 33, whatever, minutes before the doctor sees him, and he's 18 months old and he's in a dorm room on the GSW campus and there's only one person in the room with him when it happens, well, those are two direct facts, okay? Those are not circumstantial, those are two direct facts. And the circumstantial evidence is when you take those two direct facts and you make the inference, which is under these circumstances, the only thing that reasonably could have happened was this. This is really important. Judge Sizemore is going to tell you that the law does not require more or greater certainty by you if you're returning a verdict based on circumstantial evidence rather than on direct evidence per se. Okay? And that's because there is no rule that either circumstantial or direct evidence is stronger than the other. The comparative weight of the evidence is an issue for you to decide, just like it is if it's all circumstantial or it's all direct, if it's all testimony or it's all documents, if it's all video or it's all audio. Ultimately, it's up to you to make the decision as to what the evidence means and what conclusions you can draw from it. So you take those things into account, you think about it this way, you say, okay, now we know some facts, we know some direct facts. So what are the conclusions that can be reached from the direct facts? Well, I suggest to you that there's only two possibilities, okay? One is that it's accidental trauma, that's a possibility, or that it is inflicted trauma. Those are the only two possibilities. But accidental trauma, ladies and gentlemen, is not a realistic explanation. It's not even close to a realistic explanation in this case. It's not a realistic explanation, well, for a whole bunch of reasons. Okay, it's not realistic because you would say, how many times you fall off the bed now? How do you have this bruise and these bruises and these bruises? Okay, and they're not just bruises. Okay, I'm not picking up and showing them to you again. Okay, but you saw the medical examiner showed you. I mean, where they put it, like you're looking at the scalp on either, the skull on either side. Okay, there's brain bleeds here, and there's hematomas here and here and here, and then there's bruises here and here and here, and those things don't all come at one time. Those don't come from one fall. Maybe if you fall off the side of a mountain, and you roll 500 feet, bouncing every which way, you might bruise your whole body. Okay, they might occur in one event or at one time if you're in a car wreck, and there's one impact and you get impacted from every angle. But those kinds of injuries, it is not realistic to think that they could be the result of accidental trauma when there is such a collection of them, and they all occurred within the same reason, within the same time frames. I think is what Dr. Clark's testimony was, that he thinks that those injuries, because they're consistent with each other, they're all new, they're all fresh injuries. Okay, the Dr. Oleg testified about the liver, for instance. She says that the liver, that you can tell that it's not an acute, it's not a chronic condition. It's not something that's been going on, but you do that from the lab results, because you look at the lab results and the liver enzymes are up in, they're not 20 times higher than they're supposed to be or 100 times higher. Okay, the liver enzymes in one case are like 200 plus times higher than they're supposed to be, and the other 400 plus times higher than they're supposed to be. Okay, and the reason the liver enzymes are so jacked is because it is an acute injury. It is something that has just happened within a short period of time. Now, none of the doctors are specific about that injury or about the bruises. They're not as specific. They're not saying we can narrow it down to an hour, or within minutes or whatever, because, there is a broader range in which those things could occur. But when they are there, when they aren't there, and then suddenly they are, and when they are there, they are in the presence or they're associated with or in addition to an injury that can be timed or dated, then you know that they almost certainly occurred all at the same time. Accidental trauma, talks about falling off the bed. The only evidence in this trial of a fall from a bed, all of it, the whole total of all the evidence. Nobody was told by Trinity Poague at the hospital that fell off of the bed, that the baby fell off of the bed. Jay Williams wasn't told that he fell off of a bed. Okay, the police officers that she ran across at the hospital weren't told that she fell off the bed, that he fell off the bed. Dr. Bussman said that he remembers. He said he didn't have a specific. He said he didn't know if there was a specific note, but he didn't remember for sure. If she said chair or what, but something about a fall. And he says all I know is that when I asked her about it again a few minutes later, she completely changed her story. Okay, that's what Bussman told you. And that's not Bussman going back and looking at notes, that are recorded by somebody else, etc. Okay, that's Bussman's memory. He says, I can't tell you what the stories were, but I can tell you that it changed significantly from the first time I talked to her, the second time I talked to her. Okay, so the only evidence of fall off of a bed is this. I'm sorry. I think I skipped something here. But anyway, so you saw the message earlier, and I may have it out of order, and if I do, I'll apologize for that and try to do better next time. But you saw the text, you've heard it already, where she says that she told Jay to get on the bed, or she put the baby on the bed with Jay, and Jay let him roll off the bed. And she says, he's okay, he's fine. Okay? So, not only did she say he's fine, but her next text to Paris about what happened is this. Paris, this is when she's at the hospital. Paris says, did they say what happened or why they think that? She says, he hit his head at some point. I don't know. They won't give us much information. And Paris says, wait, didn't you say he fell off the bed last night? And her response is, I don't know. I was asleep. She doesn't know if he fell off the bed. That's what she tells Paris the next time the topic is raised. I don't know if he fell off the bed. I was asleep. The next thing she tells Paris is 3 hours later when they're talking about the skull fracture. Paris says, you texted me last night and told me he fell. That had to be it. And Trinity Poague's response is, but that was only off the air mattress. And the air mattress wasn't far from the ground. I can't text about it anymore. I don't know what's going to happen to me. So you have the one text, which is the only evidence of a fall from the bed, and in the next two text messages concerning that matter, Trinity Poague says, I don't know if he fell off the bed because I was asleep. Oh, and he just fell off of an air mattress, rolled off of an air mattress. Not only that, but the timestamps, and I think this testimony was in earlier. Okay, the message about he fell off the bed was at 11:57 p.m. on Saturday night. Okay, at 12:02 and 12:04, and I will tell you that I'm not 100% certain which one of those two videos that this screenshot comes from, but it's from one of those two, either at 12:02 or 12:04. Okay, either not, maybe more than 10 minutes after the child fell off the bed, but it is 5+ minutes since she sent the text saying he fell off the bed. Okay, that is the state of J.D. Angeles. Okay, and you saw the video in court. That's a screenshot, of course. And you look at it, ladies and gentlemen, and there is no big fresh bruise on the corner of his forehead. And he's sitting up, and he's drinking out of a sippy cup, and he was holding on to her hand and playing, as you saw in the video. Dr. Oleg, okay, who's also not affiliated with the GBI or anyone else, I mean, other than her own practice, Dr. Oleg told you that there is zero possibility that following this injury, the child could be doing these very things. The nature and extent of the injuries can't be explained by a fall from the bed. Too many injuries, too serious. They don't happen like that. And Mr. Gill says, you know, he's like, Dr. Clark, you just can't trust Dr. Clark. Now, he works for the GBI. You know, he works for the crime lab, which is true, he is technically an employee of the GBI. He said, you can't trust Dr. Clark. You know, because Dr. Clark's going to say whatever they want him to say, I guess. You know, it's what he's implying. It's not the case. Okay? Dr. Clark does autopsies, right? Sometimes the autopsies are, this is a natural death. This is a heart attack. Sometimes the autopsies are, this is an accidental death. You know, sometimes the autopsies are, you know, the death is unknown, it's unexplained. Okay? And those he doesn't get called to testify because nobody's being prosecuted for murder. Okay? The only time he gets called to testify for murder is when he made the finding that this evidence establishes that this was a murder. Okay? He doesn't get called to testify in a murder case because we decided that, oh, we got a murder case. Well, hell, what are we going to do? You know, let's call Dr. Clark. That's not how that works. He does the autopsy. He did the autopsy 3 days after the child died. Okay, issues a 6-page report, orders all kinds of stuff. Okay, comes into court, and yeah, you know, we're going to call him, right? We're going to call him to testify because his actual live in person with his hands and a scalpel findings were that this child was murdered. So of course they're going to call him. So Mr. Gamble says, you know, he says, but Dr. Clark ain't slick as he thought he was. He says, because I got him good now. I had this article. He got an article. Where's he going to find the article? Was that up here?
I don't know the deal. I think they gave it back and we couldn't send it to the jury. So I can give you that.
It's all right. Okay. This is the thing about the article. Dr. Clark says, well, give me a minute, let me read it. We took a little recess. Okay, he read the article. Mr. Gamble comes back and he says, 4-year-old child in Chicago fell off of an adult bed, died 2 days later of an epidural hemorrhage. You know, 9-month-old in, you know, Portland, you know, fell off of a table, you know, suffered an injury, was taken to the hospital and they did not have any findings, died 2 days later from brain trauma. And Dr. Clark says, yeah, he says, I'm not only familiar with Dr. Case or whatever her name is, he said, I'm familiar with her. He says, I'm familiar with the article. I'm familiar with it. He knows the other doctor too that's cited in there, Mavo or whatever his name was, who she cited. Okay. He says, yeah, I know these people. Okay. And I know this article now that I've looked at it. He says, they're talking about epidural hemorrhages. Okay. An epidural hemorrhage is entirely different than a subdural or subarachnoid hemorrhage. And he explained on the stand, and I hope that you got it because, frankly, I probably didn't understand it well enough to try to repeat it to you. But basically, there's different layers between the, you know, from the skull to the top of the scalp. There are different layers. There's the galeal layer, which is the fibrous tissue that's immediately attached to the skull, and then above that, there's the dura and the something and something else. Okay, and you can have brain hemorrhages. You can have hematomas that resolve. And they occur in different levels, and depending on what level it occurs on, it's subgaleal or subarachnoid or subdural or whatever. The article was only about epidural hemorrhages. And he said we had a very small epidural hemorrhage in this case. The significant ones were subdural, subarachnoid, and subgaleal. Okay? Article has nothing to do with the facts or the circumstances of this case. Furthermore, you go to the next section of the article, and it says that in almost all cases of subdural hemorrhages in a child, it is the result of abusive head trauma, which is exactly what it is a result of right now, in this case. How many times you fall off the bed? There's an occipital skull fracture, which is back here, the back of the head. It's a hard bone to get to. It's a hard bone to fracture because your shoulders absorb some of the blow if you fall backwards, and this part of your head absorbs some of the blow. And it's the thickest bone in the scalp, or in the skull, rather, the occipital. It's the thickest bone in the skull, he said. Hard to crack, hard to bust, hard to split. It not only split, it not only busted the full thickness, the fracture went all the way through the occipital bone, but it continued into the parietal area. Okay, now, Dr. Clark didn't call it a parietal fracture. He called it a separation of the lambdoidal suture, okay, which is where the two pieces of the skull come together over here, right? And the reason he called that is because it was on the suture line. Okay? But the sutures, they all develop at different times. The sutures solidify. They come together and ossify in the bone at different times in different children, different ages, and depending on where it is in the head, but it says this is bone. Okay, it was just on the lambdoidal line. Okay? The other doctor who did the X-ray, and this is what Jill Olick testified to. She said it's an occipital and parietal fracture. Okay, but in any event, the fracture goes from here all the way up here. There's bruises on the face side in front of the head. There's a lacerated liver and a lacerated adrenal gland. He didn't have any of these conditions or injuries when he got to Americus on Saturday night. So did he fall out of a chair, right? That's the, we went from falling off the bed to falling out of a chair. And I will tell you the same thing that I told you about the other fall, because it's just as applicable. The nature and extent of the injuries cannot be explained by a fall from a chair, particularly not a fall from this chair. That chair, the part that you would fall over, okay, is only 13 inches off the floor, okay? So if you fell over that, there's only the only way you can fall out of that chair is to fall forward. You can't fall backwards in it. Y'all, everybody here probably has seen one of these chairs or something like it before, I bet. And the kids probably have had one and all that. And it's a big fluffy, probably is kind of a beanbag thing. The cushion's beanbaggy. It's not a whole beanbag chair, but the cushion's beanbaggy. It's a big fluffy thing. Okay, when you sit down in it, okay, the way it's shaped like a dish, you sit down and you basically sink into it. Okay, you couldn't turn the thing over backwards, if your life depended on it, not from inside of it. Okay, and if you fell forward out of it, even if you were only 18 months old, if you fell forward out of it and landed right square on your face and busted your forehead and did this and that and knocked out an eye and all kinds of things, you still wouldn't fracture the parietal bone and you still wouldn't fracture the occipital bone. If the injuries cannot be explained by falls, the only realistic possibility is that this child was a victim of inflicted trauma. Okay? There's just not another explanation. It's either accidental or it's inflicted. And if it's accidental, if it's not accidental, it has to be this. And if it has to be this, if it's this, then it has to be by who is the question. Okay? So, Jay Williams. Did Jay Williams inflict the trauma on this child? That's one hypothesis he offers. Okay, I was kind of stunned by this one. The other possibility he offers is, JD himself. He's active, climbing, growing, 18-month-old baby. He might have done this himself. There's no telling what he climbed up on and fell off of. Seriously, that's what he said. He said that to you. Like, you don't believe that? Like this child, managed to come. Now, if somebody had come out of that bathroom where they were, okay, and the child had been laying face down, not breathing and unconscious and in respiratory arrest and with brain fluid seeping out of his mouth and his nose, okay, if you've been laying like that face down, on the side of the desk over here, and that was the only injury he had, sure as heck, it could be accidental in that case. Yeah, it might be. But to think that the kid climbed out of, it's too dumb for me wasting more time. I'm running out of time. For me just wasting more time talking about it. That kid did not climb on anything and fall off and hurt himself. So the only other option, the only other person is Trinity Poague. Now, I'll grant you that this case depends in significant part on the credibility of Jay Williams. I mean, it does. You know, every case has witnesses. Some witnesses are more important than others. Some witnesses are essential to a case. Some witnesses, you know, are kind of interchangeable. You can use this one or that one or whatever to prove whatever you're trying to prove. Jay Williams is an essential witness in this case. Okay, but I'm telling you, when you assess his credibility, the judge can give you a charge about assessing credibility. Okay, like you consider their manner of testifying, their circumstances, how they would know the facts and circumstances that they're testifying to, their ability to observe, you know, whether it's corroborated by other testimony. Okay, his testimony was corroborated by clear, undisputed evidence. Okay, there is a video from GSW that Chief Lewis played for you. Okay, that shows him walking out of the dormitory at 11:55, and shows him walking back in at 12:30, and shows him running out with a baby squeezed up against his body right here at 12:31. Okay, he wasn't there. Not only that, said he's going to get a pizza. Well, you know, how about this? There's pizza, okay, right there on the end of the bed. You know, says he's going to Walmart. Well, there's Walmart bags, and there's stuff in the Walmart bags. And you reach in, you know, and you take it out, and you take a picture. You know, and I'm not, so. Well, there's Walmart bags. There's a receipt that says that these things in this Walmart bag were paid for at 12:14 p.m. Okay, so he left the dormitory at 11:55, and he's at Walmart walking out at 12:14. I'd say he's moving pretty efficiently if he managed to get there and to pick up items and get through the cash register in 19 minutes. But he did. Okay, his statements to Allen and Mathis. Okay, to Mathis Wright. I said Mathis. I should have said Wright. I'm sorry. His statements to Lieutenant Allen and Reverend Wright were consistent not only with what he told them, they were consistent with what Poague told them. Okay, they're consistent with what she told them about falling out of the chair, etc. Right? Big deal about the hospital records. Ladies and gentlemen, when you consider the credibility of this witness, I'm telling you, the hospital record does not disprove his testimony. It barely contradicts it. It barely. I mean, it's almost it's not a bump in the road. I mean, it's a pebble of sand that you walk over. Okay, the hospital record doesn't disprove his testimony. There's no one who comes in here and testifies and says, you know, this is what he told me. I wrote it right here word for word. I know this is what he told me. Okay, there's a hospital record that's assembled by a team of people who are working desperately to save the life of an 18-month-old child, and doesn't disprove anything about what he said. His GBI interviews do not impeach his trial testimony. Okay, let me talk about this for a second. I talked about it briefly a while ago, but I want to go back to it for just a moment. The GBI things, okay? Pardon me, I'm sorry. I have to take a sip of this water. What he told Samantha Ford was that he didn't know what happened to the child. Okay? Now, defense counsel didn't play the interviews for you. He didn't refer him back to specific questions. He didn't refer her to specific questions to say, what questions did you ask him? Did you ask him what happened? He says, I don't know what happened. You know, she says, have you heard anything? Well, yeah, the only thing I've heard is what Trinity told me. You know, I mean, what Trinity told him isn't nearly as important in for summarizing the interviews. Okay, it's not nearly as important in Jay Williams' interview summary as it is in Trinity's interview summaries. Okay, so you know, he says, you know, what do you do? You know, what he say? He said, well, he told me he didn't know. That's what he said. He said he didn't know. And it may very well be that without those questions being in front of you to know what questions were being asked and how they were being asked, that may have been the full and only and absolutely correct answer. Moreover, his trial testimony was credible. The guy sits there, not showing a lot of emotion. You know, it's been 2 years. You know, you come into a courtroom, there's a lot on the line. You know, you're seeking justice for your baby. Okay, there's a lot on the line, and there's y'all. Okay, and y'all are a wonderful looking group of people. Okay, but I'd be scared to death too if I was sitting over here. Okay, and I'm testifying. You know, and I'm asking questions, and Mr. Gamble's asking questions, and are all, you know, giving him a mean eye. You know, not kidding, you really giving him a mean eye, but you're all looking at him. Okay, you're paying attention to him. Okay, you're focused on him, and he knows you're focused on him. Right? That is a tough position for somebody to be in. And you try to control your emotions because you don't want, I mean, anybody would. You try to control your emotions because you don't want to break them. You don't want to look, you know, like Jell-O on the witness stand. Okay. So you steel up, you know, you tighten up. You say, okay, I'm going to get through this, you know, and you sit there and you do it. You answer the question cleanly, directly. Okay. You answer them crisply. And that is the thing, if you think about, that you will recall from his testimony. That guy didn't evade a single thing, okay? He's not trying to dodge anybody's question. He's not dodging. He's not ducking and dodging. He's not giving you this, you know, I don't know. I don't remember. That was a long time ago. You know, I mean, he's answering the questions the best of his ability based on what he remembers at the time he's sitting there. His demeanor was appropriate. His grief was palpable. He's at this point, he's testified, okay? He's in the courtroom when this happens. And Mr. Gamble says, he says, well, about this jacket that the baby supposedly threw up on. Supposedly threw up on. Okay? So I go back in the records, okay, in the recordings that we have, right? And I look and I say, are there any pictures that actually show the jacket where it's puked on? Well, sure enough, you have it back there. You look at it a little closer, and you see just how prominent that is. Okay, it is all down wrong side, all down this side of the jacket. Okay, it's not only down this side of the jacket; it's inside the collar. Okay, I mean, it makes my stomach weak just to hear that. Okay, but listen, I love my children. I love them for all the world. Okay, but my ex-wife was a nurse. Okay, and when youngins started throwing up. Okay, I do everything. I changed diapers, I cooked meals, I did all kinds of stuff. Okay, the youngest started throwing up. I'm like, Betsy, come here. Because I couldn't stand it. Okay, it makes me cute for them to do it. This guy tucks that child against his shoulders, gets in a car, races to the hospital, and while he's doing it, this kid is puking on him, not on his clothes, not on the floor, not on the seat of the car, or in a baby bed somewhere. He's puking down his neck, down his shirt, inside his jacket. Okay. He doesn't let go. He doesn't stop holding him. He doesn't stop going to the hospital. He doesn't get to the hospital and say, here, somebody take this nasty young'un. Look, he's done yacked all over me. He carries him in until he puts him in the hands of somebody who might try to save his life. And we're gonna mock him and say, supposedly someone threw up on this jacket. Come on. He was credible. He was credible to what he testified to. And ultimately, ladies and gentlemen, there is this. He has no reason to harm his son. And Mr. Gamble says, you know what? They should have gone to Courtroom and talked to neighbors and friends and all this kind of stuff and asked about all that. And, like they should have been investigating Jay Williams. Well, first of all, they make him sit through 4 hours of interviews, on the first day. Right. And they take his phone. Okay. They do a search for a search warrant. They snatch his phone too. Not one, two phones. They snatch 2 phones from him. Okay. And they're listening, but when they're the dormitory interviewing people, okay, they're not interviewing people to say, tell me what you know bad about Trinity Poague. Okay. They're saying, tell me what you know about this baby being in the dorm last night. And then from there, it may go on to other questions, but saying, what do you know about the baby being in the dorm? Left. Gone. Okay. So that's what they're asking for. They're not trying to build a case or attack the character of this girl. That's not what they're doing. Okay. And there's no reason to go to Courtroom because I tell you this, okay, you got an apartment in Courtroom, right? If this child had died in Courtroom, Georgia on Sunday, January 14th, 2024, okay, and Trinity Poague had been there in Courtroom with them when it happened, you think they're going to be coming up here talking to people that live on the dorm? No, they're going to be talking to people in the apartment next door, in the apartment across the street, the people that he sees in the parking lot, people that he sees at work. But those people don't have relevant information in this case, okay? They might have relevant information. If this child had died of malnutrition, okay, if he had died as a result of, septic shock for some wound that didn't get treated, okay, if there was a negligence case or something like that where you have a baby that just doesn't get taken care of, okay, where defects has been involved, all these kinds of things, you have that, then sure, you go interview the neighbors, etc. Okay, J.D. Angeles died because something or someone smashed him in the back of his head and cracked his skull open, and then smashed him again and split his liver. Okay, he didn't die because he had some sort of chronic abuse. He didn't die because he cried at night, and the neighbors somewhere else didn't hear him. Nobody's aiming for Trinity Poague. Nobody's aiming for Trinity Poague. Hey, I'd rather have a different defendant. Okay, if it were me, right? If I got to choose who my defendant is, I'd rather have somebody that looks mean and surly, and is older, and somebody looks at him and says, oh, he just looks terrible. That looks like a guy who would do this. That's what I'd rather have as a defendant. Not an 18-year-old college student, 19, 20, whatever she is.
Wait a minute. Did y'all hear that? Did y'all hear him? I don't know. Did y'all hear that? It may be because I got the thing up. Because I got it speeding up. He sound like I don't know, was he growling like I wanted that's what he sounded like. Oh my gosh. Did y'all hear that? He was like, if I wanted another defendant, that's all I heard. Wait a minute. What is going on with him?
Evade a single thing, okay? He's not trying to dodge anybody's question. He's not dodging. He's not ducking and dodging. He's not giving you this, I don't know. I don't remember. That was a long time ago. He's answering the question the best of his ability based on what he remembers at the time he's sitting there. His demeanor was appropriate. His grief was palpable. At this point, he's testified, okay? He's in the courtroom when this happens. And Mr. Campbell says, he says, well, about this jacket that he maybe supposedly threw up on. Supposedly threw up on. Okay? So I go back in the records, okay, in the recordings that we have, right? And I look and I say, are there any pictures that actually show the jacket where it's puked on? Well, sure enough, you have it back there, you look at it a little closer, and you see just how prominent that is, okay? It is all down, look, wrong side. It's all down this side of the jacket, okay? It's not only down this side of the jacket, it's inside the collar, okay? It makes my stomach weak just to hear that, okay? Listen, I love my children. I love them with all the world, okay? But my ex-wife was a nurse, okay? And when youngins started throwing up, okay, I do everything. I changed diapers, I cooked meals, I did all kinds of stuff, okay? Youngins started throwing up. I'm like, Betsy, come here, because I couldn't stand it, okay? It makes me puke for them to do it. This guy tucks that child against his shoulders, gets in a car, races to the hospital, and while he's doing it, this kid is puking on, not on his clothes, not on the floor, not on the seat of the car, or in a baby bed somewhere. He's puking down his neck, down his shirt, inside his jacket, okay? He doesn't let go. He doesn't stop holding him. He doesn't stop going to the hospital. He doesn't get to the hospital and say, here, somebody take this nasty young'un. Look, he's done yacked all over me. He carries him in until he puts him in the hands of somebody who might try to save his life. And we're gonna mock him and say, supposedly someone threw up on his jacket. Come on. He was credible. He was credible as to what he testified to. And ultimately, ladies and gentlemen, there is this. He has no reason to harm his son. Now, Mr. Campbell says, you know what? They should have gone to Cockwood and talked to neighbors and friends and all this kind of stuff and asked about all that. And, they should have been investigating Jay Williams. Well, first of all, they make him sit through 4 hours of interviews, on the first day. Right. And they take his phone. Okay. They do a search for a search warrant. They snatch his phone too. Not one, two phones. They snatch 2 phones from him. Okay. And they're listening. But when they're the dormitory interviewing people, they're not interviewing people to say, tell me what you know bad about Trinity Poague. Okay. They're saying, tell me what you know about this baby being in the dorm last night. And then from there, it may go on to other questions. But saying, what do you know about the baby being in the dorm? Left. Wrong. Okay. So that's what they're asking for. They're not trying to build a case or attack the character of this girl. That's not what they're doing. Okay. And there's no reason for them to go to Cockwood, because I tell you this, okay, he got an apartment in Cockwood, right? If this child had died in Cockwood, Georgia on Sunday, January 14th, 2024, okay, and Trinity Poague had been there in Cockwood with him when it happened, you think they're going to be coming up here talking to people who live on the dorm? No, they're going to be talking to people in the apartment next door, in the apartment across the street, the people who he sees in the parking lot, the people he sees at work. But those people don't have relevant information in this case, okay? They might have relevant information. If this child had died of malnutrition, okay, if he had died as a result of, septic shock for some wound that didn't get treated, okay, if there was a negligence case or something like that where you have a baby that just doesn't get taken care of, okay, where defects has been involved, all these kinds of things, you have that, then sure, you go interview the neighbors, etc. Okay, J.D. Angeles died because something or someone smashed him in the back of his head and cracked his skull open, and then smashed him again and split his liver. Okay, he didn't die because he had some sort of chronic abuse. He didn't die because he cried at night, and the neighbors somewhere else didn't hear it. Nobody's aiming for Trinity Poague. Nobody's aiming for Trinity Poague. Hey, I'd rather have a different defendant, okay? If it were me, right, if I got to choose who my defendant is, I'd rather have somebody that looks mean and surly, and is older, and somebody looks at him and says, oh, he just looks terrible. That looks like a guy who would do this. That's what I'd rather have as a defendant. not an 18-year-old college student, or 19, 20, whatever she is. They're not after Trinity Poague. They're trying to determine how this baby died and who was responsible for it. Now,
Mr. Lamb, it's been a little over an hour, so I'm going to let the jury have a brief recess. We're just going to make it a 10-minute recess, and then we'll let Mr. Lamb conclude his argument. Okay?
thank you, Eric.
Judge said, give us a break. God, you've been going for over an hour.
Just before 12:30.
Okay, let me see. Let me make sure they still deliberating. Yes, they are deliberating. It's at 2 hours and 7 minutes. Okay, let me show y'all this. Let's do a little break in between this. I got two little side check things I can show y'all. I was looking for the one, but this is the one that I came up. This is the one that came up when I pulled it up. Y'all, this is like 6 days ago. I can't with this. I can't. Let me show y'all. So I kept laughing because it say Mistress sleeps in the casket in front of wife and kids. So when you go in there, you see this. I'm like, oh my gosh, she cannot be all the way on the husband's casket. Like, I don't even know if I'm going in. This is the side chick in the husband's casket? Really? I couldn't believe it.
Everyone, and welcome back to the channel. This video has been going viral all over social media. So I thought I would bring it over here. Situation, jump in. I told you that your camera was. Oh my God. No. That's why they stopped blowing the casket. That's why.
I'm glad I wasn't the only one that we be laughing at this crap. Even the person that's covering, she laughing. Oh my God. Like who does that? Like she like sitting like, man, if I was the wife, I would have started throwing dirt on that. Just start throwing dirt on that hoe. Like, really? Is this what we doing? No, I'm throwing dirt on you. You want to go with him? You want to go with him that bad? A little real. Let's get the dirt on her. So I guess somebody from their uncle's, it was their uncle's funeral, and I guess they posted it. That's where she got it from. But wait a minute.
This is 20 minutes before.
Come on now, you can't do that. Now calm down, calm down, calm down. Stop it, calm down, calm down, calm down. Come on now, calm down, baby, calm down. Come on, somebody. Hi, boo. How are you? It's okay. I'll go with it.
Oh God, she like, I want to go with him. Oh God, that he wasn't even her husband. Her like, she like, I want to go with him.
You can't go with him.
Not you want to go with him.
I can see the casket hasn't even been pulled down or something, right? So it hasn't been dropped into the ground or anything. You can tell this is an African American funeral, so I'm assuming they were into a I don't know. All these people look black, so I don't know. But let's see. So
Oh, okay.
See, right here is why Uncle Charles and them. She had.
wait a minute. I just really want to see how she got in there. Yeah, it don't show me. I want to see.
For coming to that.
I don't know. I don't know if it's
Not one single.
Mama says she not getting out.
They show. And then they got her.
Oh, y'all, the comments after this situation.
I don't know, but I don't know how you even do this. How do you do this? Yes, it is. And she said she was getting in there. Oh gosh, I cannot with some people. Like, come on. But she said she was getting in there. She said she was getting in there. I want to go with him. All right, I would have threw some dirt on her. Here you go, boo. You go right in there. Gone. You be 6 feet under with him since that's what you want to do out here. So this one right here, guys, this is the one I originally was looking for. I know. I'm pretty sure the comments were off the hook. I'll see if I can find it on real video. I don't know if I can find the whole full video where we can read the comments. I didn't want to go through their video too much over here at Okay, so she's saying this is her uncle's funeral. She's a side piece. His wife and kids were there, and she started spitting on people. So they started, and she started, I don't know. So this is her. So she the author. I guess it's her video. Oh, okay. So it's her uncle. Oh, okay. So it's her uncle. So I'm assuming this is on her thing. But oh my goodness. So this is my other little side. So this is at the funeral. The police actually were called to this one. It's a young wife putting her husband to rest, and I guess the side chick shows up and she decides that she wants to, I don't know if she want to attend the funeral or what, but yeah, let's see what this one is. So just for some context, this is it'll have some sound. I know the person that does it where I got it, they kind of talk over it a little bit. So I'm kind of waiting. So this is the wife. They're going back there to talk to her. So this is the wife in the red dress right here. And of course, y'all see the officers right here. Let's see.
So, again, I apologize. I just want to do everything the right way. But there's, it's right here. Well, I got a license plate number of the person I'm talking about. She was outside making direct threats. I didn't allow her in. That's why I had my family watching the door. She's allegedly of her husband. So she's making direct threats. She knows exactly where I'm at. She knows my phone number. She knows my address. She's making direct threats. He's got the threats. And she got me on the wrong day. I'm telling y'all.
Yeah, this is a disrespect.
I was sitting right there by the front door.
She was by the front door?
No, I was by the front door. I was sitting inside
There's
here.
another female out there in a green dress.
That's the one I'm talking. No, she's not a white female.
Okay, there was another white female in a green dress. I'm sorry.
She, like I explained, she had single braids, and there was a half bun on top.
So what did she exactly say to you today?
I got witnesses. You can get witness statements as well. We never direct. So she got it. Excuse me, give me a second. Oh, I'm sorry. I'm so sorry. It's right here.
She's gonna talk. Crystal, hold on. Okay. Put your hands behind your back. For what? Put your hands behind your back. For what? Put your hands behind your back.
What is it for? What am I gonna arrest her for? What's she getting arrested for?
You,
Did y'all tell her she was under arrest and what for?
you're under arrest. You're making some threats.
She didn't make no threats.
We've got witnesses. I need you guys to step back. I need you to step back. We'll talk to you in a minute, okay?
She didn't make no
I need you guys to
threats.
step back for now, please.
Y'all let you
Back up. Is there anything else you want them to take for right now?
Ms. Jones and Mr.
We'll let you talk to her in the car. We'll explain to you. We'll explain it to you.
Excuse me, can one of y'all talk to her parents and inform her parents? After y'all put her court, back up, bruh, back up.
What you
Back
going
up
for?
from the police. Back up from the police. Sorry, it's my hand on your back, sir.
No, you're fine.
And I don't
I
want
mean,
to
she's a grown woman, so. But we'll talk to her parents. Yeah.
Just go down there. We will be out. It ain't nothing, okay?
Let's have a seat.
My dress.
Yeah, you're fine.
No, I need her to pull my dress over. Please.
Can you pull her dress up over?
That's her dad. Hold on, dad and mom stand over there. Everybody else back up from here.
Back up. She's an adult. She's an adult. I will talk to everybody else later.
Come on, y'all see the aggressiveness? Just be smart this time. Back the fuck up.
Trying to do this as respectful as possible. I know there's a lot going on. How old are you?
20. I'll be 29 tomorrow.
29. Here's the deal.
This is cutting my neck.
I can try to put a little bit there. There were allegations of threats made that you said you were going to put her in the ground next to her husband.
I haven't even made contact with her.
There-
She wouldn't even let me in the building.
Right.
I ain't made contact.
Well, we're
Everybody out here can
we're
tell
hearing
me
it
that.
otherwise, okay? And so she's going to have to go down. She's going to have to press charges and that kind of stuff. Right now, you're going to go with us. Okay? So that's what it is the threats. It's menacing. You're threatening to kill her by putting her in the
Do I
ground.
really look like
I know emotions are high. There's a lot of different stuff going on, but this is what's
everybody out here
going
can tell you I ain't saying that. That's his sister right there.
right.
Like,
So that's
get
where we're
out.
at today. Okay.
That's the thing. When she told me, like, I can go in there between 4 and 4:10 to see. I said, okay. She said they just want you to, leave for right now till everybody leave. I said, okay. That was my car I was getting into,
Right.
but everybody is leaving at the same time
Right.
and passing in front of my car. I can't hit nobody trying to get out, and then I'm not
Right.
driving. So you asked me to leave, but she told somebody else. She told somebody else
Right.
that that she was
Right.
gonna let me see, and that
Right.
she just wanted me to leave for now. I was okay with that.
Okay.
But I couldn't get out. Clear when y'all even walked over there, y'all see it was a car blocking my car.
Right. There's stuff. Right.
So how am I? You
But
asked me to leave. How am I supposed
Right.
to leave if I can't even get in my vehicle?
And
get
we
out?
didn't ask you to leave.
No,
We
not
didn't-
y'all. I'm saying
I know.
she did.
And we didn't tell you or nothing like that.
No, that's fine.
The reason you're going to go down today is because of the threats. Now, here's what happens. She has to go down and talk to the prosecutor. If she follows through with the charges, that's on that. It's going to be a misdemeanor. Your people can bail you out within an hour or so, okay?
And how
And
much is
handle
that
the
gonna
stuff
be?
through in courts.
Now, how much is that gonna be? So I can let my family know.
I don't know the specifics. I don't want to give you a dollar amount and promise you something that's not true.
So can you let my family know that?
Yeah, we can let your mom and them know that, hey, you're going to go down. It's a misdemeanor charge. They should be able to bail you out within about an hour or two. Okay? But the sooner that we can get you down there and get that process started without having to deal with emotions
So
and
is
everybody
somebody
here.
gonna call them? Like, can y'all get one of their
You should be able
numbers
to make a phone call.
All right.
You'll be able to
You know
make a
their
phone call.
numbers?
You know
I
their
just
numbers.
know my mom's. I don't.
That's
just
about the
know
only
my
family
mom's.
member I know is my mom.
I just know my mom's number by
Will
heart.
that work?
Okay.
I can write a phone number down for you.
My mama answer. Mom, just stay with Cupcake for me, please. Mom, I'll be all right. They just said, give me an hour or two. I'll be all right. Just give me an hour or two. Y'all can come get me.
Ma, give me an hour or two and I'll be there. You know what I didn't understand about this when I first seen it? Is usually like the police, I don't know, y'all could tell me. Usually when it's something like this, do they like arrest you right then, like because of some threats? I mean, because like That mean that anybody can blame anything on somebody and they take you to jail for some threats? You say you don't understand any of it. So, Barbara, if I say that you threatening me and I feel some kind of threat, the police can come and get you and take you to jail, even though I don't have anything to, I don't have a voicemail, I don't have a note, I don't have a witness, I don't have anything. Menace? I thought that they tell you just to get away. You know, like the police come and say, okay, you got to leave. You got to leave. And then, like, you know, sometimes they be so extra that the police be like, well, forget
But here's stuff, you know what I mean?
It's not.
Let's let the courts handle the stuff.
If you really want to be technical, it's her people's. It's her own people. I done had a whole dude out here threatening me. I didn't call the police because I know emotions is high.
Right.
That's the thing. I'm not that type of person.
Right. I understand, and I'm not saying you are. You know what I mean? We're caught in the middle.
I'm in a whole dress and sandals. Like,
all right, I'm gonna shut the door, okay? I'm gonna shut the door, okay? I'm gonna shut the door, okay?
What police department?
I'm not talking to your attorney. We're dealing with her.
I'm trying to represent her. Get her
Basically, threats were made.
You're not an attorney.
We're addressing the threats right now.
You have to contact her.
So about what we say doesn't count because she didn't threaten nobody. Well, we've got the victim and witnesses who say this.
Oh my goodness, that tell you. Now, why had this guy back here talk about he attorney? Y'all hear him back there talk about I'm an attorney? I'm an attorney. I'm here to represent her. Man, if you don't kick her,
She didn't threaten nobody. I understand that's what you believe. That's what I know. We have to go.
It's okay. Yeah. Situation where
it'll be menacing.
Her family just
take these off my head and give them to my mom.
I can. Do you want me to take your jewelry as well?
Yes. That boat tight. There's only 2 of them that's gonna slide over my neck.
Okay. The bigger ones?
The bigger ones are gonna slide over down.
Husband dies and wife's here at the funeral and alleged girlfriend shows up. She made the comments and it was confirmed by funeral home staff about I'm going to put you in the ground next to him. So everybody's carrying guns. They don't want her side of the family here. So
Her side being girlfriend or wife?
Girlfriend.
Okay.
So, and they continued to stay here surprisingly when we were inside getting all the information. So she's just going to go down for misdemeanor. Once we took her into custody, I mean, everybody swells around.
The rest of the family?
Most all of them did. That's mom and dad and brother. Where's
Don't leave before I leave.
This is the report number. We're going to need you to go down to the prosecutor's office tomorrow, 8:30 in the morning. Talk to the prosecutor. So that's going to be at address is 335 West 3rd Street, 3rd floor. Talk to the prosecutor. I'm taking her to jail. The rest of the family members. But if you don't go down and press the charges, nothing happens. Follow through with protection orders and stuff like that.
I was supposed to do that this morning. I swear to God, my uncle took me downtown to get the papers. They told me the magistrate wasn't seeing nobody today until like 2:30. And I'm like, I won't need to be.
Yeah, you're doing this. So unfortunately, this happened before that. But go down tomorrow.
The suspect was taken to the local.
So do they got matching dog tags on? Because she looked like she had on a dog tag too. Like the side chick and the white, did they both have on matching dog tags? So the staff heard her threaten the wife. I tell you, like that, man, besides not being able to, the wife had told her she can come from 4 to 4:10 to come see him, but she had to go after that. That was a nice wife. She was like, come on, you can come see him from 4 to 4:10, but then you got to go. And then she didn't want to leave. Yeah, they said somebody heard her threatening her before. And this one, man, I don't know. This one right here, y'all better go get your cousin. I don't know whose cousin this is that jumped all the way in the casket, but they better go get her. Shoot, before somebody be throwing some dirt on her. Girl, if you don't kick rocks, I want to go with them. Shit. Not even for a husband. For somebody that's married to somebody else, she'd have jumped all the way in the casket talking about take me with them. What the hell? Oh my gosh. I probably would have thought about, yeah. And his wife and his kids was there, and she up there doing this old mess. Girl, if you don't get somewhere. I don't know. Y'all better get y'all cousin and get y'all cousin off of this thing. out of this cat. Like she done went down. Because the casket look like it's in the ground to me. Or maybe it's not. Maybe it's up. I don't know. It look like it's in the ground. I don't know. She is goofy. Like, you can't make this stuff up unless you see it. Yeah, that look like it's in the ground. Don't that look like it's in the ground to y'all? It look like it's in the ground to me. Oh, you at the airport. Well, thank you so much for checking in. You came at a very juicy time. I mean, you can't make this stuff up. Nope.
Hi, Will. How are you? It's okay. I want to go with him.
She said they won't let me see you. I want to go with them. They should have tossed her ass in there. There you go, boo. Go with him. Hey, we got a 2-for-1 deal. Yeah, so that's what I was cracking up on, because every time I would look at her on top of this casket, I could not take it at all. What were we doing? Oh, we was listening to that guy. I don't even know. I probably lost him. Shoot, I don't even know what I did with it. Wait a minute. Oh, she was really crying. Sheesh. Let me take us back in here. I gave y'all your little funny break. Hopefully I woke y'all up a little bit and watch some other stuff. But let me see. It don't look like he got much more to go when they come back from break. I don't think. Let me see.
Room, okay, but he says he could happen in this 5 minutes. That she's in the shower and he's out there with the baby. Okay? There is nothing about Jay Williams that would lead you to believe or support the conclusion that he would have done this to his child. Who had a motive? If you could have a motive, right? Like these cases are hard. Okay, I think Mr. Gamble may have misinterpreted me when I said that this is easy. I'm talking about, that element of the decision-making process becomes easy when it gets to this kind of case. Okay, but these cases are hard because these are the cases where every jury is going to give every defendant the absolute most presumption of innocence and the most benefit of reasonable doubt ever, because in your heart of hearts, like every other living, breathing human being, okay, you don't want to believe that somebody could do something so terrible to somebody so innocent. Okay, nobody wants to believe it, right? So if you get past that, ladies and gentlemen, your deliberations, you get to the point where, you know what, I believe it, okay, you've passed the reasonable doubt stage, okay? Because you're giving her, anybody else, you're giving anybody in this position, because you don't want to believe it. Nobody wants to believe it. So how do you make yourself believe it? How do you accept that Trinity Poague could do such a thing? Okay, yeah. So she have a motive. She resented and ultimately despised that little boy. Okay, now you know this from her statements, her text messages, etc., starting back in August of 2023. Right, starting in August of 2023. These are in evidence. Remember, they started these exhibits. These are the text messages that came from Paris Permort's phone between her and Trinity Poague. He started the back and moved forward because because that's the way they're stacked up here. And she says, "I'm going to sleep in your room. I can't do JD crying that much. Hopefully he's in a better mood in the morning." Okay. Then she's talking about getting in the shower and she puts him in there, wash him in the shower, and he gets water spraying on his face, and he apparently didn't like it and was acting reacting to it or whatever. And she says, "I'm trying to take a shower and I had to bathe him, and I just sat him down and let him cry because I'm not about to baby him." Okay. I'm not going to baby a baby. When she's talking about Jay Williams, I'd say, I don't blame you, girl. I wouldn't baby him either, right? No grown person. She's talking about a little kid. She's talking about a kid that stands that tall, okay? That's unsteady on his feet still. And she said, "I'm not going to baby him." The witnesses that came and took the witness stand that were called by the defense said, "Oh yeah, she didn't like that young. She didn't like him. She didn't like him. And not only that, he didn't like her. He didn't like her." She sends more messages in August 17th of 2023. She says, "Why do I feel anger towards JD? When we were in the bed and JD kept touching Jay's face, I almost cried." Okay? Because the kid is being affectionate towards his daddy, it's upsetting her. And Paris doesn't understand. She says, "What do you mean? Like you feel anger towards JD?" She goes, "I don't know, not jealousy, but I want to love him. But instead of loving, I just feel like angry, like I want to punch him." Laughed my ass off. Oh my God, that sounds so bad, doesn't it? Yeah, it does. It does. It does sound that bad. And then the explanation comes in the next two messages. "Ever since he's gotten here, Jay has not touched me. He's currently on the floor." Okay? The baby is interfering with her relationship with Jay Williams. Later, 5 days later in August, she sent a message to him, to Jay Williams, and she said, "I told you from the beginning I would always try to love JD the same as mine. But since me and you've gotten serious, every time I see him, I just get angry at the world, and I just have a gut feeling of anger. I don't know what it is. But just seeing him makes her angry." In December, she sends a message and says, "Yeah, I'm going to come back there. Let's go to January." The day before, the night before, he was murdered. She says, "What are y'all going to do about tonight?" That's Paris's text. And the response is, "No clue. I guess I'll probably sleep on the air mattress in the sink area. I can't do being around JD anymore. He hates me and I hate him." And if you examine her conduct towards the child, ladies and gentlemen, you will see that, in fact, that is true. There's an old saying that says, when people tell you who they are, believe them. November of 2023, she told Jay Williams that he had hit his face, had hit his eye, that he bruised his eye or cut his eye, injured his eye, that she was cleaning up near the camp in the bathroom, and she didn't realize he was behind her. And she opened the door or the drawer. I don't remember which one he said, but she opened it up and she hit him in the eye, hit him in the face. She said, I felt so bad. I felt so bad. Okay. Where is JD when he gets the blow to the face? Okay. With Trinity Poague and nobody else. He ain't with his daddy. He's with Trinity Poague. In December of 2023, she sends a message that says, Jay, this is December 17th. She says, Jay, I don't know if I can do this anymore. This weekend was a struggle for me, and I don't know what to do. I love you so much, but letting JD hit the wall and see the damage it did really hurt me. Okay? What in the world is that about? Hitting the wall. I asked Jay Williams when he testified, he says, I don't know. I don't know what she was talking about when she talked about him hitting the wall. That baby was terrified of her. You heard those people that said he cried and cried and cried when she was there, and he would stop crying if somebody else picked him up. That was his reaction. There's an old saying, something like, I never trust people who don't like dogs, but if a dog doesn't like a person, I trust them completely. And I'd submit to you that basically the same thing is true of an infant. Okay? Like, you don't like babies, you don't like little kids, you don't think they're fun and I don't know, cuddly and snuggly and just wonderful, creatures, I'm sorry. If you're not that person, okay, and little kids know, okay, they know it's like, they're not going to go to that guy. They're not going to go to that girl. They don't want any part of her. Okay. And there's these things that have happened, and they happen when he's with her. Okay. And in this case, ladies and gentlemen, this is really important. I'm going to try my best not to run out of time, and I'm sorry, I didn't mean to talk this long. In this case, he says she hasn't given any confessions or anything, like they don't have anything on her. That's what Mr. Gamble said. I wouldn't have said that. Couldn't say that if he hadn't said it first. There's not. He's right. There's not. Okay. But there are implicit admissions that this case happened under her care, under her eye. Okay. There are implicit admissions that this happened. One of those implicit admissions is that she lied about what happened. Okay. The second one of those implicit admissions is that she changes the story. She creates essentially two separate events in talking to two separate sets of people to explain it. Okay. Third, she sends the text when she's at the hospital, and she sends the text to Paris. She says, I babysit all the time, and nothing like this has ever happened. Okay? Okay. Now you parse that statement. You think about what that statement means. Okay? If I say, Stephen Douglas drives my lawnmower all the time, and nothing's ever happened to it. Okay? Until now. Right? I'm blaming Stephen Douglas. Okay? I'm saying this is different for Stephen Douglas. He drives my lawnmower. He doesn't normally break it. But he did this time. Okay? If I say, if he breaks my lawnmower, okay, but I say, I've had this, I have had this lawnmower for years, and nothing's ever happened to it, okay? And then I turn around and say, it's an implicit admission, and my analogy may not be very good, but I think that you get the point, okay? That if she wasn't involved in this, if she didn't do anything, then the answer is, I don't know. Not he fell off the bed. Not, oh, no, what off the big bed, it was off the air mattress. No, it fell off the chair. No, it didn't fall off the chair, slumped over in the chair or something. Okay? I don't know is the answer if you don't do something. But if you do something, you're trying to explain it, or trying to absolve yourself of attention and criminal responsibility, then you come up with other things and other people to blame, etc. All right. I've left this part for near the end, and that is talking about this offense, malice murder, okay, which is a separate charge than felony murder. Person commits the crime of murder with malice aforethought and causes the death of another human being. Okay. The court is going to charge you, I think, that there's two kinds of malice. Express malice is a deliberate intention to kill, which is manifested by external circumstances that are proven. Implied malice is when there's no considerable provocation and circumstances show an abandoned and malignant heart. Okay. Ladies and gentlemen, there is implied malice in this case. There is implied malice. Okay. Now, I will not tell you, and the judge is going to charge you. Okay. He's going to tell you that we don't have to prove. Nobody has to prove that because foreplan, that they were planned premeditation. We don't have to prove premeditation. Okay, that's not part of the burden of proving malice murder. He's going to tell you that malice can be formed in an instant, and in an instant, a mortal wound inflicted, and it's malice murder. Right now, the reason that I'm bringing this to your attention is because you could reach the conclusion from this evidence, okay, that she either just lost it for whatever, that he left her with the baby again, he's going to get pizza and drinks, she's already mad because the baby's ruining her weekend and all that, okay, and he left the baby and the baby won't shut up, the baby was crying last night, half the night, she, had to get up and go to Paris's room till 2 a.m. and she's trying to play with the baby and wake him up. And now he leaves her with the baby again, and she gets out of the shower and he's crying and he won't shut up and she just flips out. Okay. And maybe she doesn't. Maybe she doesn't intend, I don't think what I think doesn't matter. I'm not trying to prove and I'm not trying to suggest to you or make you believe that she looked at him and said, I am going to kill you. Okay. Like that I'm not trying to convince you of that. Okay. But I don't have to convince you of that for you to find malice murder. Okay. What you have to find for there to be malice murder is that there's no provocation and the circumstances show an abandoned and malignant heart, that there's just a point at which somebody just goes too far. Okay. And when you use your hands or the edge of the bed or the edge of the desk or the floor or the wall or whatever the weapon was to cause this kind of damage, then the evidence is sufficient to show that she's guilty of aggravated battery and first-degree cruelty, felony murder, and malice murder. Now, Mr. Gamble has made a big deal out of, as he should as a defense lawyer, about reasonable doubt. And he says, this is reasonable and that's reasonable. Okay, the judge is going to charge you that we don't have to prove doubt beyond all certainty or to a mathematical certainty. We don't have to prove guilt beyond all doubt or to a mathematical certainty, right? And we don't have to disprove every ridiculous hypothesis or allegation made by the defense. Like I do not have the burden, frankly, of proving to you that this child climbed up on the dresser, and did a high dive on the floor, of his own accord, because he had one injury, not a whole panoply of them. Okay, I don't have to prove that. I don't have to disprove that hypothesis because it's not reasonable. It's just dumb. And when you look at it, you say this is not reasonable. Okay, so if there's some hypothesis that he's tossed out there that I haven't addressed, that doesn't mean that I failed to prove it. You can take the evidence and analyze the evidence and say either this hypothesis has been disproven or not disproven, or this hypothesis is not worthy of attention in proof. When you consider the evidence, something else you take into account that there are two specific false narratives. Okay, and these are not just arguments that are where somebody's off track on something. Okay, these are false narratives. Okay, that have been promoted to you since opening statement. In this case, I just didn't get to say anything about it until now. Since opening statement. Okay, that the diaper. It's not said directly, but it is implied, okay, that the reason James Gibson threw away the dirty diaper when he was examining the trash out of the trash bin on January 14th, the reason he threw away the dirty diaper was because there was a defense motion to test it. He files a motion and said, ha, we don't have it. It's gone. You know, when I had to come to court and answer for it. Okay. That's not what happened at all. Okay. Gibson, as you heard from his testimony, I mean, made an independent judgment. Okay. Maybe he's even wrong. Okay. Everybody's wrong sometimes. You know, there's not an agent that's good enough not to make mistakes. There's not a lawyer, you know, a doctor, a cab driver, a carpenter, anybody else that's good enough that they never make a mistake. And maybe Gibson's wrong. I would stand by the decision he's made as his fellow agent has done, but it had nothing to do with an expectation or worry or fear that it was going to be tested. What he had to do, and the fact that it was photographed, unfolded and photographed, doesn't mean that he saw it as being of special importance, but he wanted to hide it. Okay, if he saw it as being of special importance and wanted to hide it, he wouldn't have photographed it. The photographing is like everything else was in the trash bag, and he told you, you know, he says, I opened up chip bags and cups and wrappers and all kinds of things. Okay, he photographed everything in there, not just the diapers. Okay, the second false narrative, okay, is that Jay Williams isn't legally JD's father, and maybe he's not, maybe he is, maybe he's not. Okay? But that has nothing to do with this case. It is a fact. It is a reference that is not even necessary to have been made in any context or circumstance whatsoever. Okay, it is designed to make you think that these people, the family of this child, do not deserve the same measure of justice that somebody would if they could say, you know, not only is me and my wife, you know, but I've got 9 DNA tests to prove it. You know, this is my kid. Okay? Can't do that. Can't do that. Certainly can't do it now. Okay? I bet he'd love to have a paternity fight now. You know? Love to. Say, yeah, I'll fight about it. You know, and if I lose, I'll kiss him on the cheek and say goodbye. Okay? But he can't. Whether he's his father or not has nothing to do with anything. Petty contradictions due to different perceptions or memory lapses. And we talked about this before, and I'm not going to go into it much further. Okay, somebody says, "Oh, look, this is what I said," and they said, "No, that's what you said." And it's been 2 years or more, and they're in 2 different contexts and 2 different, you know, 2 different eyes viewing things, or 2 different sets of eyes, and sometimes they don't see things the same way. Failure to find or recover a weapon or other physical evidence at the crime scene. He says it can't be a crime scene because there's no blood. Okay? Some crime scenes don't look like the Manson family has been there. Okay? Some crime scenes, you know, there aren't walls full of bullet holes. Some crime scenes, there's not anything in the room that specifically points to it and says a murder happened here. Okay, why would he not luminol the whole room looking for blood? Because he had just left the hospital and the child didn't have any external injuries. Okay, there's no blood because he wasn't bleeding. Whatever happened to the injuries that he suffered resulted from blows and force that caused him to have internal injuries.
Wait a minute.
There's no weapon. Well, you know, that really ain't right.
Oh my goodness. Y'all ready to hold hands? We got a verdict. Oh, y'all ready to hold hands? Oh my. Oh my. Oh my. Wait a minute. I'm trying to rewind it. Wait a minute. I don't even know when I kept doing the thing. Oh, it just came out. Okay. They get on my nerves the way they do this stuff sometimes. Oh my goodness. I don't know. Can somebody go make sure, Barbara, make sure you holding somebody's hand. But either way, the way this go, this is stupid. They're about to make me mad with Court TV. This is stupid. Wait a minute, y'all. Hold on. They done about pissed me off. I'd be so mad that we have to listen to court TV for certain stuff because all this time they've been sitting up here playing this whole silly mess. Wait a minute. So it looked like 2 hours, 27 minutes, and 50 seconds. Here, let me share. I don't like them sometimes. Like, this shit is stupid.
Question from the, I presume it's the foreperson. Is that right? And it reads as follows. What are the following? Count 2, felony murder. Count 3, felony murder. Count 4, aggravated battery. And count 5, aggravated battery. And then it says, e.g. is 1 for the head and is 1 for the liver. And I'm going to respond to this by asking you to refer to the indictment. The indictment has the allegations contained in it. You have to review the indictment. Then you consider the jury instructions that I gave you, and you have to make a determination. You determine the facts. I've given you the law as to each of those offenses that are charged. And, you know, like what is aggravated battery, what is felony murder, what is cruelty to a child, and what is malice murder. You have to determine on each, you know, with regard to each of those charges, considering the allegations in the indictment, whether the evidence supports that, given the burden of proof that I've instructed you on in some detail, and the facts as you find them to be. But I can't really answer your questions. I'm not going to try to interpret what the allegations of the indictment are for you. You do have the indictment with you. Is that correct? Okay. All right. So I'm going to ask you to return to the jury room and resume your deliberations.
All right. I agree with what the judge did, Michael. He simply said to the jury,
information. Let me ask you this. And Walsh in Massachusetts. Walsh is accused of murdering his wife. Were asked questions about an interest in those types. The subject matter that's contained.
I'm trying to skip it. I just wanted to make sure I skipped it appropriately because I couldn't find it good at first, okay? But here we go at the beginning of it. I was trying. Everybody hold hands. Kumbaya. I already have my phone here, so I can't even tell nobody. She looked like she stressed out the day she went on. The other day she had on lashes and everything.
Mr. Foreperson, does the jury have a verdict? All right, if you would pass that to my bailiff, please.
Now remember, this is not long after they asked a question.
All right, Ms. Poague, if you would please stand. The verdict reads as follows as to each count. On count one, it says, we, the jury, find the defendant not guilty. On counts 2, 3, 4, 5, and 6, the verdict reads, we, the jury, find the defendant guilty of felony murder, 2 counts, aggravated battery, 2 counts, and cruelty to child in the 1st degree. Y'all can have a seat. Ladies and gentlemen, it's been a tough week for you, I'm sure, and I know that you probably had a lot of places you would have rather been this week than here. I do want to thank you tremendously for your service. You have shown up, you've been on time, and you've paid thorough attention. You've taken in a lot of information this week, and you obviously, from the fact that you've deliberated over this, you've looked at this very closely. So with that, your county appreciates the work you've done, and you'll receive a stipend. It's just a token of the county's appreciation. You are free to leave for the term. You're also free to, you can certainly step back into the courtroom through the other door if you wish to, or hang around if you want to speak with the lawyers, but you don't have to. You don't have to talk to anybody. You're welcome to leave at this time if you prefer. If you do, turn in your badges on your way out, and make sure that your notes are in the jury room. And I really appreciate it. Y'all are free to go. Oh, was there anything we hold the jury for just a second? Ask them to step into the jury room. No, ask them to step into the jury room. Ask them to just step into the jury room. Yeah. Chad, if you'll pass this down, please pass this down to the lawyers. I do want to let you all review the verdict form and let me know if there's anything else that either of you are asking me to consider. All right, may the jury be released. Mr. Lamb? Yes, Your Honor. Mr. Gamble?
Yes, Your Honor.
All right. All right, my proposal would be to let's proceed with sentencing. I would like to give you all about 15 minutes and come back in and I'll hear from both sides, and then I'll pass sentence. So it's 4:35. I'll be back in at 10 minutes until 5, and go ahead and hear from both parties and conduct sentencing. Thank y'all. So all right. Mr. Foreperson, does the jury have a verdict? All right, if you would pass that to my bailiff, please. All right, Ms. Poague, if you would please stand. The verdict reads as follows as to each count. On count one, it says, we, the jury, find the defendant not guilty. On counts 2, 3, 4, 5, and 6, the verdict reads, we, the jury, find the defendant guilty of felony murder, 2 counts, aggravated battery, 2 counts, and cruelty to child in the 1st degree. Y'all can have a seat.
I had to go back and look at that because the judge looked shocked. She looked shocked. And then her face, when it came back up, it looked super shocked. Oh my goodness. Okay. So they are going into sentencing. So let me see. Okay. So it's on a short break while we go into sentencing. I'm surprised they going into everybody was shocked. The judge like, what the wait a minute, what? But her face, boy. I hope he read it right.
All right. Mr. Foreperson, does the jury have a verdict? All right, if you would pass that to my bailiff, please. All right, Ms. Poague, if you would please stand. The verdict reads as follows as to each count. On count one, it says, we, the jury, find the defendant not guilty. On counts 2, 3, 4, 5, and 6, the verdict reads, we, the jury, find the defendant guilty of
We didn't listen to the jury instructions, so we don't know what was charged to her, but they about to do the sentencing now. I was gonna go back and go look at it. I mean, we still can, but we didn't hear that part of it. So let's go back in the courtroom because they're doing the sentencing.
All right, we're going to address sentencing. Before we do that, I want to see if there's any disagreement as to merger of the charges or vacating any of the sentences because of the. I know that the aggravated battery charges merge with the felony murder charges, and I believe the cruelty to child does as well. But I want to see what both parties indicate.
Yes, I don't think they agree.
Okay, what is your position on that?
The state's position is that, of course, the court could impose sentence on that. You go straight down the line. The court could impose sentence on count 2, which is felony murder. Count 3, felony murder, would be vacated because you can't be sentenced for 2 murders in the same case when there's only 1 victim. Count 4, aggravated battery, would merge with count 2, felony murder. Count 5, aggravated battery, would stand alone because you would only merge 1 felony with the felony murder, not 2. Even though the felony murder, because the felony murder is. Well,
can I see the indictment? Will you hand me up the indictment from the?
I mean, I have a copy of it. I don't know.
It's with the exhibits.
Is it in that?
Well, if you have a copy, that'll be just.
I just counted all the exhibits. I didn't even think about that.
I don't know. I do have.
You can hand it up. That's fine, Laura.
I do have a copy.
Right.
So
let the court reporter sit back down.
Yes, sir. Yeah, please. All
right, let me ask you this question. Felony murder in count 2 charges her with murder based upon the commission of aggravated battery by causing blunt force trauma to the head and torso, right?
Yes, sir. But that "and" is interpreted disjunctively, and I mean.
Let me finish my thought pattern,
yes,
and then
sir.
you can tell me your response to that.
Okay.
Count 4 charges her with aggravated battery by rendering his brain useless, and count 5 by rendering his liver useless. And then count 2, felony murder, charges him with aggravated battery for both of them. I mean, in either way, right? To the head or the torso. So why wouldn't both merge into count 2?
But first of all, with respect,
can we take a break? Are you looking for the indictment? Yes. Okay. If it's not in there, then they need to hold everything in that. Okay. All right. All right. Okay, you can go ahead.
So even though which count is the count 2 is the one that relates to the aggravated batteries?
Yes.
Is that right?
Yes.
Okay. And so it refers to an aggravated battery based on damage or to the brain and to the liver. That
head and torso.
Or head and torso, right? That "and" is should be interpreted disjunctively. In other words, if there was a finding that only a battery to the head, that would be sufficient to support a claim. A finding of guilty on felony murder. If there was a finding of aggravated battery only on the torso, that would be sufficient to support it. So since either of them will support the felony murder, only one of them merges. And then count.
How do I know which one merges?
First one. If you go straight down the list of charges, okay, and you get count 3 is vacated, count 4, merge with count 2, and then now there has been a merger for count 2, which means count 5 would not merge; it's left freestanding, And count 6 can't merge because count 3 was vacated. So the sentence should be on felony murder and on count 5 aggravated battery and count 6 cruelty to children. That is the state's position.
All right, Mr. Gamble.
Yeah, we disagree on that interpretation. I believe that the court is correct concerning the merger of the aggravated battery. That the only charge that should stand is the first count of felony murder, which is number 2. And then the others would have merged in one way or another and be out. And then the only other charge could be cruelty to children. I believe would be the only one that remained with the felony murder. That's our position.
Do you happen to have any case law that addresses this particular situation?
Yes, sir. I mean, if the court wishes to take it.
Maybe we should take a recess.
Well, I'm looking right now, Judge.
Okay. And I did say, I mean, you do agree that then the felony murder, the 2 felony murders, 1 vacates. Right?
Yes, sir. Count 3 is vacated. That's correct.
Okay. But the fact that count 6 would have merged with count 3 doesn't affect count 3.
No, sir. Once it's vacated, then there is nothing for it to merge with.
Okay. So the question is, and I think Mr. Gamble agreed with that. The question is whether count 4 and 5 merge with count 2, because the felony murder charge in count 2 included both, whether it's, I guess it says and, you say that says is the disjunctive, which means or,
right?
But it includes count 4 or 5 or 4 and 5. I mean, they could have found him guilty of both. Well, they did. They did find her guilty of both. So I guess I need case law on that. If the state is seeking a sentence on aggravated battery count 5. So we'll take 30 minutes. Mallory, you come with me, and we'll take, I'll give you I'll alert you when I'm ready to address that.
Look, I'm just talking and running my mouth, and y'all can't hear me, but I just don't understand what is going on. Thank you, Baca. Because I'm like, I don't even understand what's going on. The judge don't know what he's sentencing. Like, how you gonna sentence somebody and you don't know what's going on? I mean, did they send the appropriate stuff back there with the jury? I was just a talking. I know. I was just a talking. This is a mess. The judge don't know what's going on. The attorneys don't know what's going on. So they talking about they're gonna come back in 30 minutes, right? So because we didn't get to hear them doing the jury instructions and stuff, y'all want to listen to that part again? Y'all, I mean, not listen to it again. We should listen to that part, right? This is what happens when they overcharge people. Because he like, we need to merge some charges, and the prosecutor like, no. We're not merging nothing. Keep everything separate consecutively. Your ears need a break. What is this, the judge? I want to hear what he charging because I don't know. And everybody's asking and we don't know. I don't know how he charged the jury, how he instructed them. Oh, whatever. Whatever, Baca. I guess. I don't know. Did he go let her hug him? What you know, Jason? I don't know what he charged, what she was charged with, because everybody kept asking about what was malice murder. What was the malice region? I don't know. They said she did. That's what Baca said. I didn't see it. Yeah, I didn't see that. Even when I'm going back and looking, I don't see it.
Pass this down. Please pass this down to the lawyers. I do want to let you all review the verdict form and let me know if there's anything else that either of you are asking me to consider.
Yeah, I don't know if they have different.
Doesn't affect.
No, sir. Once. Them merges, and then count.
How do I know which one merges?
First one. If you go straight down the list of charges, okay, and you get to, count 3 is vacated, count 4, merge with count 2, and then now there has been a merger for count 2, which means count 5 would not merge. It's left freestanding, and count 6 can't merge because count 3 was vacated. So the sentence should be on felony murder and on count 5 aggravated battery and count 6 cruelty to children. That is the state's position.
All right, Mr. Gamble.
Yeah, we disagree on that interpretation. I believe that the court is correct concerning the merger of the aggravated battery. That the only charge that should stand is the first count of felony murder, which is number 2. And then the others would have merged in one way or another and be out. And then the only other charge could be cruelty to children. I believe would be the only one that remained with the felony murder. That's our position.
Do you happen to have any case law that addresses this particular situation?
Yes, sir. If the court wishes to take it.
Maybe we should take a recess.
Well, I'm looking right now, Judge.
Okay. You do agree that then the felony murder, the 2 felony murders, 1 vacates, right?
Yes, sir. Count 3 is vacated. That's correct.
Okay. But the fact that count 6 would have merged with count 3 doesn't affect count 3.
No, sir. Once it's vacated, then there is nothing for it to merge with.
Okay. So the question is, and I think Mr. Gamble agreed with that. The question is whether count 4 and 5 merge with count 2, because the felony murder charge in count 2 included both, whether it's, I guess it says and, you say that says is the disjunctive, which means or,
right?
But it includes count 4 or 5 or 4 and 5. I mean, they could have found him guilty of both. Well, they did. They did find her guilty of both. So I guess I need case law on that. If the state is seeking a sentence on aggravated battery count 5. So we'll take 30 minutes. Mallory, you come with me, and we'll take. I'll give you some. I'll alert you when I'm ready to address that.
I don't know. So they going on break for 30 minutes. Let me see what else we got out here while they on break. I don't know what happened with the Cardi B thing. I heard they pushed it back. Hmm. I'm trying to see if it's something on here that's interesting for us to watch. Look at this one here. She said, "How about a clip from your business, knowing her lawyer throwing her lawyer down in court? You know you love you sister business." I bet you SDV just watching her stuff over and over again. Look at this. These people is weird.
Star executed a man inside a national park. The victim, someone who she once accused of rape. The woman once known as Selena Savage on OnlyFans is in prison. She pleaded guilty to murder, but she is not going quietly. Why she says what she is ordering.
And personal.
Gosh, that's a big gun. She's saying, I don't even know how to spell her name. This one.
The dismemberment process was awful.
For the first time, we're hearing gruesome dismemberment details straight from the defendant's mouth as Taylor Shabusiness stands trial for the murder of her ex-boyfriend.
I didn't want him to die, actually. He's my buddy, but like it happened. I just didn't stop. I don't know why. I didn't stop. I felt bad because I'm like, damn, he's gonna be the reason that I did this. I'm like, might as well just kill it.
But when did you start, cutting up his body?
I don't know, like almost right away. I was sucking and cutting at the same time.
25-year-old Taylor Shabusiness now stands trial for the murder of 24-year-old Shad Therion, who investigators say she strangled to death in February 2022. Shabusiness faces a first-degree murder charge and 2 additional charges for dismembering Therion's body and sexually assaulting his corpse after his death.
I hate this outfit. Never in my life.
For the first time since her arrest, we're hearing from Shabusiness herself about the incident. On day 3 of the trial, jurors were shown multiple interviews from the Green Bay Police Department made after Shabusiness was taken into custody. The defendant described the grisly crime in great detail.
When I was dismembering the body, there was, I'm going like this with a knife, so there's blood fucking going everywhere, sorry.
As Shabusiness explained, it started as what the victim believed would be kinky sex, but quickly took a darker turn.
You two being intimate, having sex.
It was getting there.
Or do you like doing this? Did you his penis in your vagina? Okay, you just trying on it?
I'm looking at the week of May 15 for the trial.
Stop it. Stop it. Rachel, call.
Is they bring a 7 in? Yeah, let's just go to secondary. And then we'll stand by there.
Billy, can you walk?
Watch breaking.
Stop.
Oh, the judge face is absolutely comical. Y'all see his face? He like, what the fudge? Look at his face, y'all. I don't know. Was she trying to stop court that day? Okay, they back in court, y'all. Let me put us back in there.
That the sentence that the court is going to impose is for counts 2 and count 6.
Yes, sir. I advise Mr. Gamble that after doing some additional research, or some initial research rather, on that particular question, that I think that 4 and 5 would merge with count 2, and that being the case, the state's position is the court should sentence on count 2 and count 6, which I understand is the defense position as well.
Correct.
Yes.
Yeah, that's what I was finding too. I had never seen a case where you could back a charge out of the felony murder, even if it was. Of course, there's very few cases where more than one felony are charged in a single count of felony murder. But at any rate, then count 3 will merge. Will be vacated. Count 4 and 5 will merge with count 2, and count 6 is a standalone offense based upon the merger of count 3. The vacation, the fact that count 3 will have to be vacated. Is that correct?
Yes, sir.
All right. I'll hear from the state concerning sentencing as to count 2 and count 6. And of course, if you want to present any witnesses, you certainly can. And I believe the sentence possibilities are life on count 2 or life without parole. And on cruelty to children in the first degree, the sentencing range is 5 to 20. 5 to 20. Okay. All right. All right. I'll hear from the state first.
The state proposes that the appropriate sentence in this case would be a sentence of life in prison on count 2, with a sentence of 20 years consecutive on count 6. I understand that Ms. Poague is very young. I think this is the terrible tragedy of these kinds of cases. I have a baby as a victim, and who was at the time a teenager as the defendant, and I think that the jury's verdict. It's not always very possible to get an interpretation of what the jury might have been thinking. But I think if you look at the way the verdict is structured, that it suggests to me, at least, that by finding a not guilty on malice murder, that there was a belief that there was not evidence of a specific, essentially a specific intent to kill or a deliberate intention to kill. And that would be the distinction between count 1 and the remaining counts. And so, in my view, if I accept that as a finding of fact, from my perspective in proposing a sentence, if I consider that or accept that as a finding of fact of sorts, that there's evidence of malice, that there's evidence of disregard, conscious disregard for the consequences of her actions, then I feel justified in asking for consecutive time. But if I do not believe that the evidence supported this jury in making a finding of a deliberate intention to kill, such as would support a malice murder conviction, then I'd feel constrained to leave the recommendation at life without parole. At life in prison as opposed to life without parole.
All right. Do you wish to present anything? Anybody wish to say anything from the family, or are you presenting any testimony?
No, sir. We're not presenting any testimony, and I'm not the father of the child is not father and aunt are here, of course, but I'm not asking them to make statements to the court, and I've told them both that they could if they wanted to do so, but we're not going to.
Okay. Mr. Gamble?
We recognize felony murder. I don't think if they're recommending life with parole, that's as lenient as the sentence could be under that particular charge. I don't think you can go below life in prison for a felony murder charge.
Right.
So we don't dispute that. We would ask, though, Your Honor, the cruelty to children, they're asking for consecutive 20 years. If you put that on there, you're coming very close to being life without parole, in that she will not come up for parole currently for 30 years and then add 20 more to it. Would be very close to her entire lifetime. And we would ask the court to consider, you've heard the evidence and you know generally what the whole circumstances were. She was 18 years old at the time, a young girl that had not had any trouble with the law, any problems, and was doing well. Now, obviously, she's accused of a horrendous crime that we fought about in court, but we accept the jury has made a verdict, whether I agree with it or not. So she has to now face what the consequences are of that. But it should not be so severe that it would be akin to life without parole. And that would be what happens if you make this consecutive serving time sentence. So we would ask that on the cruelty to children, that it run concurrent with the life sentence that she is going to be imposed on her for the felony murder. So felony murder plus 20 years, but run concurrent with the felony murder charge.
All right, Ms. Poague, if you'll stand up, please. I don't do a lot of speaking when I'm passing the sentence. I've heard the case and I've considered the tragedy on the left side, on my left side, and on the right side. And there's a lot of tragedy to go around here. The whole time that I'm hearing a case, I think about what the appropriate sentence would be. And this conduct all led, in my opinion, to the offense of felony murder, even the charge that, would have merged with count 3, but does not because count 3 is vacated by count 2. That's a lot of technical jargon. But the bottom line is you're going to receive a sentence of life in prison, which is the appropriate sentence for the conduct that you have been convicted of. And that is going to essentially be the sentence that the court passes in this case. You will be sent on, so on count 2, I sentenced the defendant to serve life in prison. And on count 6, I sentenced the defendant to serve 20 years in the state penitentiary. Those sentences will run concurrent. I do wish to advise you, Ms. Poague, that you have 30 days to appeal. You also have 4 years within which you could seek habeas corpus. I hope this can bring some closure to the family. It's just a complete tragedy. And I hope that you can, in your older days, have some sort of life after serving this sentence. And life while you're in prison. You just have to make the best of it. But that's the sentence of the court. I wish everybody the best.
Forward it to Mr. Gamble for review and then to Your Honor.
Thank you.
wanted to address a couple of things. I reviewed the emergency motion for temporary relief, Mr. Smith, and it does appear as though a lot of the allegations alleged within that motion are really in the nature of contempt. I know that there is a contempt proceeding, a contempt hearing being held on December the 17th, I believe, before Magistrate Valentine. The court's purpose in the hearing today is only to address the issues as it relates to an emergency. So as I'm looking at the motion, the paragraph specifically that the court will address would be related to paragraph 7. The 16-year-old child is now a suspect in the death of the stepchild during the cruise. While
I step away for 1 minute. So she got 30 years. I done missed the whole thing. Let me see. This is a battle. This is about the little girl that was on that cruise. Well, not little girl, she was grown. The grown girl that was on that cruise that they had a motion, emergency motion. Let me see what we got here.
And that being the case, the state's position is the court should sentence on count 2 and count 6, which I understand is the defense position as well.
Correct.
Yes.
Yeah, that's what I was finding too. I had never seen a case where you could back a charge out of the felony murder, even if it was. Of course, there's very few cases where more than one felony are charged in a single count of felony murder. But at any rate, then count 3 will merge. Will be vacated. Count 4 and 5 will merge with count 2 and count 6.
So basically, she gonna be able to apply for parole when she turned 48, and she still got the possibility to have a baby. They didn't have no victim impact statements or nothing. Dang, they ain't say nothing. You say you hope there's a press conference. I don't even think it's gonna be no press conference. They ain't say nothing, Rachel. I don't think they're gonna be doing nothing. I don't know. They probably say she been rehabilitated if she get parole after 30 years. They probably give her some. They probably say she can be rehabilitated. But I don't think who gonna say something, because I don't think this case was really like out there like that. I don't know. Maybe it was out there in Georgia like that. My guy's face right here says it all. He like confused. He looking like, oh my gosh, did she just attack him? My guy here. You're so goofy. Now she got to be wielding like this. Look at her, oh crazy ass. Oh, wait. You ain't talking about a crazy ass. I mean, what can you say about that? That's a crazy ass. Oh, I don't know with the mother of the child. I don't know. She might have been in court. I don't know. You know, the mother of the child, she was married with other kids. You love that girl. That's where your craziness come out of, SD. Well, as long as you don't start acting like her, you can love her as all you want. Just don't start acting like her. And we good. Yeah. You want to say that, Jason? She a deadbeat. She a deadbeat mama. You can't say that about the mama. No, I'm just playing. I'm just playing. We got deadbeat moms out here. Yeah, she was married. She said he can keep his baby, and she going to Mexico. Okay, so we got another one that bit the dust today. I am going to try to do a bathroom chronicle this evening. So y'all make sure that when y'all see the alert, that's probably me in the bathroom doing my, my 1, 2, do us a little Friday night little get together. I think I'm gonna do that. Yeah, I think I'm gonna do that. And I'm gonna do a bathroom chronicle and we're gonna talk and hang out. So that'll be later. I am going to get ready to go to get off of here. My baby, she got a game tonight, and since she is the cheer captain, I am going to go see her cheer. And we're gonna be, I'm gonna go see my baby cheer tonight. We will let's plan for like maybe about 7 my time. So that'll be about 10 East Coast, 8 Central, 8 Pacific time. I think that's all the times. So it's gonna be 7, 8, or 9, depending on where you at. How about that? Remember the bathroom chronicles date or whatever I decide to do. It depends. I'm getting myself together so I can have it really get together. What you mean? Nope, stop it. Stop. What you talking about? You talking to somebody in the chat, Jason? He must be talking to somebody in the chat. So I am gonna anywho, I am gonna do one of those tonight. 7 your time, 8 Central, 9 East Coast. Well, don't you got? Oh, it's 6 for SD. Really? Oh, okay. So it's 6 for Pacific time because you're on Pacific time, right? Okay. Well, 6, 7, 8, or 9, wherever you at. How about that? You're like, well, apparently he got it together because I don't know. Yeah, so we'll do it. It'll be about maybe 20, 30 minutes, depending on how long, it takes us to get it together so we can all kind of hang out for the people that couldn't hang out early in the day because they were working. And that will be our evening recap. And I'll do some little small ones during the weekends too. So just keep your notification bell on. Hopefully I can bring some excitement or something from the Bathroom Chronicles. And please remember, what happens in the bathroom stays in the bathroom. I'm gonna make a members only after we get finished, because what happens in the bathroom stays in the bathroom. So if you don't catch it while it's live, you're gonna have to be a member to get up in there. Like I'm doing something so much. I ain't doing that much. All right, guys. Well, I'm gonna play our exit song and get ready to go to my baby's game. It starts in like 20 minutes. So this is right on time.
When SweetP taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mars on patrol, chat is showing out. This little YouTube corner's what community's about. Therapist you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mom like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and sweet and cheering folks along the way. And Maria from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're a family in the chat, side by side through every trial. SweetP leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, jokes flying fast, helping SweetP backstage, making every stream last. Then Zach's trolling, causing chaos just for fun. The resident cheater, but we love him, everyone. Here comes Maddie, handsome, quick with the line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. SweetP leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This Courtroom crew is everything we admire. Yeah, no matter what the case or file, we're forever taken to trial. Take it to trial. Shamrock keeps us trending, replay queen, holding down the algorithm like a machine. SD's razor sharp, loyal through and through. And yeah, she adores chasing nothing new. Drunky the bear with the white claws, way managing volunteers like she runs the whole land. Cynthia brings inside with take sharp and steady. Donna keeps it real, 911 and always ready. Tilly Bird's the fat queen, receipts on tap. Easy's new, but she blends right into the pack. Tennessee, hard live, try support her with pride. Melly shows up a family for cooking for his dog. A steady carrying presence through the courtroom fog. And Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Baka loves her gram, speaks truth when it's time. Micrograms with metaphors straight up sublime. Barbara biggest supporter, heart kind of vast. Looking for missing kids, hope to truly last. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvio, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. SweetP leads the way with that fire and that smile. Mods and shatters, yeah, this love is something rare. A Courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taken to trial. Just SweetP in the mouth and the chat we adore. This isn't just a channel, it's a family. And we couldn't ask for more.
Hey, Stan, she received 30 years. Okay, there, Dandy got it. Thank you, Dandy. And we'll talk about more about what trials we covered and what mess came up. I may have some updates in regards to the Cardi B thing when we do our Bathroom Chronicles tonight. Make sure you have your notification bell on. Thank you to the mods. Thank you to the chat. And guys, I will see you later on. Peace.